pretty much blind in my right eye all the way. I can't hardly hear out of my right ear. And my feeling in my right arm is starting to come back now.
All right. How does it affect your capacity to understand things and process your thoughts?
I talked to my wife about my two children, and I don't remember very much about them.
Okay.
But, you know, I don't want to roll this on as long as you guys don't either. You know, I want to just get it over with as soon as possible.
All right. Do you, there are two counts against you of both felony 5 aggravated possession of drugs that come from February 11th of last year. Do you remember those offenses?
From what I've been reading about it, yes.
Do you remember them independently of reading about them?
Do you remember them independently from reading about them? Do you remember them without reading about it?
Let me just.
Do you remember the offenses? Would you remember them if you hadn't read about them?
No.
How long has he been in jail? Since?
I don't remember. I got here like 3 or 4 months ago.
Okay, so you were in Lorraine Correctional then, right?
You were in correctional.
Yes.
Okay. How long is your sentence there?
I go home in May, don't I?
Mhm.
I go home in May, sir.
Okay.
I think it's the end of May sometime.
When did he get there? Do you know?
To Lorraine Correctional? No, I do not know.
I presume it was sometime after February 11th.
Correct. I believe that he was violated by the parole board based on this, well, not even on this case, a separate issue.
Do you know?
And we conveyed him here for arraignment.
I don't know the exact date, Your Honor. I know he was sentenced to 9 months.
On a violation?
On a violation not pertaining to this case, a different violation.
Okay.
I've been trying to contact his parole officer to get the exact violation. I've not had any success.
All right.
I took.
Are you having overall problems with your memory or not?
That's what my biggest issue is. They're saying,
When's the last time you saw a doctor about this condition?
according to, that's what my issue is with the jail right now. I just went to see the doctor in the jail. I think I told you or my wife. Last week, I went and seen the doctor, and she told me I won't be on the list to go out and see a specialist for 2 or 3 months from now.
Are you going to file a motion to deal with the competency? Because it seems to me that if he's representing to me right now that he's got memory problems to the extent he doesn't know his kids' names, that would be an issue of whether he could, and he doesn't have independent recollection of the offenses. If that's accurate, then that would indicate that he may not have the ability to assist in his defense.
Yes, that was the plan, Your Honor. I just was waiting to see what was happening today prior to filing that competency, but I will get it filed today.
Go ahead.
I understand. I don't want to be in here no more.
Okay.
Well, I'll accept what you give me. I don't want to be here no more.
Well, I can't give you anything until I find out if you're even competent at this point because of the stroke. So get that filed. We'll try to move this as quickly as we can to make a determination to resolve this thing. Anything else from the state?
Nothing further, Your Honor.
Okay, Nicole or Nicolette, get that thing filed, okay?
Yep, I will. Thank you.
All right.
Kind, you understand that. You still wish to waive your right to a lawyer.
Yes, sir.
I'm entering a not guilty plea, $500 personal bond. You're gonna go sign in out there. He's gonna take this file to the prosecutor. Prosecutor will come get you. They'll talk to you. Bond conditions, if we don't resolve it today or otherwise, you cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You understand all that?
Yes, sir.
Any questions?
No, sir.
All right, good luck to you. People against,
Thank you.
and either way, you're coming back in front of me. Daniel Curtis Giles here. 25T646053 A and B. I'm gonna need the prosecutor on this. 249. Can you come on in here, please?
Absolutely.
Thank you. All right. Good morning, your appearance?
Tim Gambler, P78192, on behalf of Mr. Giles is also present.
Sir, your name?
David Giles.
So I need to set this for trial. I made myself a note if it didn't resolve last time. So we've had 1, 2, 3 pre-trials. This is see, we had one November 20, December 8, January 15. So I got to set it for trial. So
This is only my.
I'm setting it for trial. I'll give you,
I understand, Your Honor. I just want to make sure that there are some still,
Mr. Bologna, your name?
Anthony Blanchard. Okay.
What, there's still what?
there's still some discovery issues that I need to issue some subpoenas for hospital records, try to find the identity of security guards, and see if there's any video from within the hospital. So I would just ask the court that I appreciate the fact that we're gonna set a trial date. We can set a pre-trial date. or
I
trial
will do
date.
that before that. You want a jury trial?
Yes, sir.
Okay, we're gonna set a jury trial at the end of February, Heather.
Okay, I think we just did one yesterday, Judge, on the 20th.
Who's that with again?
That one was that Carrie Moran.
That what?
Carrie Moran, she was that case from 2016. She zoomed in yesterday.
I'm gonna set this one for that date too, February the 20th at 8:30. I'm gonna need the jury instructions and I'm gonna need you to fill everything out. Like I just have to read them, Mr. Bologna, okay?
Understood, yeah.
So jury instructions due by January 16th. We'll set a final, I'm sorry, by February 16th. We'll start promptly at 8:30 on February 20, and I'll give them a final pretrial date on the first February docket.
Okay, that will be February 12th.
That's a little late, isn't it? I don't want to go that late. We don't want to have to send out notices.
Or we
if-
have Trenton on the 29th of January.
January 29th at 8:30.
That's the final pre-trial.
Final pretrial will be January 8th. I'm sorry, give me 1 second. Jury trial will be February 20 at 8:30. Final pretrial will be January 29th at 8:30. Jury instructions due February the 16th at 8:30.
Your Honor, the only concern I have with that schedule is that it's 2 weeks, gonna be enough time for me to subpoena documents and subpoena individuals' identities. This is stuff that should have been in a police report. You know, they mention witnesses, but there's no names for them. I've got to go track that down.
Well, I don't know what, I gotta move this case. I mean,
I understand that. I'm just saying, I just would like, if I could get the pretrial date, I mean, it seems like.
I'm not setting a jury trial date and having them send out notices to the public and then having them take off work and cancel vacations or will get babysitters only to have the case settled. To me, if it doesn't settle on January 29th, we're gonna go. I mean, I don't know what to tell you. I arraigned him on November 6th.
Right, and I was on this case at
December 8th. December 8th, you were on the case,
December 8th, so
I believe. I think that's what I saw.
that seems legitimate. Again, my concern is subpoenaing. I'm gonna
Subpoena.
subpoenas today.
Well, I don't know do you know what he's talking about, Mr. Bologna?
I believe there's unidentified persons that work at the hospital that he wants to figure out who they are in the police report.
Did this incident occur at the hospital?
There you go.
Well, you got. What else to tell you? I'm not gonna adjourn it again.
Can we go one more week on the pre-trial?
I only have Trenton every other week.
So there's nothing first week of February for pre-trial?
I don't have it. I have Trenton every other week. I mean,
And Your Honor, I can see what I can do. I mean, I don't know how long it's gonna take them to respond with subpoena. That's all, all I can do is,
why don't you subpoena him to the courthouse on January 29th, the records keeper? Feel free. And then Mr. Bologna will have an opportunity to get the records as well.
what time is the pre-trial?
8:30. Okay. Have a good day, gentlemen. Thank you. Aaron Arthur Lenz, 25G306-815. Good morning, Mr. Lenz. I mean, I don't have another date, right, Heather, after the 29th, right?
Correct, Judge. It's that one that was too close to the jury date.
All right, your name, sir?
Aaron.
You met with the department rep and you're going to plead to impeding traffic, true?
Yeah.
Yeah, I gotta send this to him, back to Gibraltar, John. I need to see.
There's a comment here.
It was an accident. Yeah, I'll call him. Have a seat right behind you if you would. Dale Thomas, 25G306-701. Your name, sir?
Dale Thomas.
Good morning to you, sir. You're going to plead to impeding traffic, right? To that charge, responsible or not responsible? Okay, I'll accept the plea, $150. You can go down the hall and make your payment, okay? Have a great day. Recalling Aaron Arthur Lenz, 25G306-815. Your name, sir?
Sergeant Gary Robinson.
Your name, sir?
Aaron.
Was there injuries?
No injuries, very, very minor damage.
Write that down on that document then, will you please? I'm sorry, on the step form. So you're gonna plead responsible to this impeding, right?
Yes,
You're gonna slow down and be careful, right?
yes, sir.
Okay, because you had an accident back in May of 25. You had a failure to yield in November of 25. Well, I mean, that's what they wrote as hazardous action, November 16. So you've had, what, 3 accidents in 7-8 months, right? 6 months?
Yeah.
Be careful. Okay, please. To the charge, impeding traffic, responsible or not responsible? All right, I'll accept the plea, dismiss the original charge. 215 is your total cash. You're under the hall to your right, okay?
Thank you.
Amelia Marie Geringer, 25G306780. Good morning, ma'am. Your name? All right. You're going to plead to impede, right? Responsible or not responsible to that charge? Okay, I'm going to accept your plea. I'll dismiss the speeding. All right, $160 and you're all set. Have a nice day. Good luck. Wesley, Mark Solomon Wesley,
Right to the podium, man.
25T647066. Heather, tell Amy, Mr. Wesley's here, please. Good morning,
Okay,
sir.
John.
How are you? How you doing?
So,
You're charged with, state your name.
Mark Blessing.
You're charged with fraudulent false information, and you have the right to an attorney. Would you like an attorney? Okay, we'll set you up with a lawyer and then either way you're coming back in here, okay?
Can I ask a question?
Sure.
If I show that I have insurance and.
Well, you're gonna have to talk to the prosecutor. Your lawyer will, okay?
Just have a seat in the hallway, sir.
People against Hines, Zachary Ryan Hines, Q5G 306-737 A and B. Good morning, Mr. Zelnick.
Your Honor, Mr. Hines, Edward Zelenak for the defendant's Hines station, please. Zachary Hines. Judge, we need a short adjournment. He's going to get into sobriety court. There will be a transportation issue because of where he lives. Taylor said they would accept it. I don't know if you allow lateral transfers. If you don't, then he'll cooperate here, but this is his second, Your Honor. He's a CDL driver with the city of Ypsilanti. His license is over, but because of alcoholism and other health issues, he's going to apply for family medical leave and get into the sobriety court program. There is a transportation problem getting here if you live in Belleville, right? Yes. So he won't have a license for some time. And I
Well,
don't
he
know if
won't-
you allow that. And if you don't, he'll come here, judges.
I'd rather have him come here, to be honest.
Oh, that's fine.
I mean, I'll tell you what, let me think about it. I'll adjourn this to the 29th at 8:30. And let me think about it. I just think if it's at a court that has a sobriety court as we do, you know, if at all possible, he should do it here. I mean, Judge Shackelford's got her, you know, she's got her hands full over there with how many she has. You know what I'm saying?
And I explained that to Mr. Hines. It was just an inquiry because of accommodation, but
Let me think about it.
will you be able, sir, will you be able to handle transportation if he needs to get here? Well, no, let's stay here, Judge.
Okay, January 29th, 8:30, and if you want to bring it up again, I don't have a problem with
Thank
that.
you, Your Honor.
Okay.
Just so you know that the purpose is to apply for.
No, I get it. I get it. Okay.
Does he need to see the people here again? He met with them once.
No, it's just next time we should decide he either is or isn't, and if he is, great. If he
He
doesn't,
did, Judge.
okay, good.
Just a matter of coordinating with work because once he pleads, the CDL's history is
Right.
job's history, so we need to coordinate.
I got it.
Thank you. Your
All
Honor.
right, have a good day. Be safe out there, Mr. Zelnick, and you too, Mr. Hines.
Thank you. Your Honor.
Kenneth James McKay Jr., 25B 149-883. All right, Mr. McKay, your name?
James here.
Officer McParlin needs to be brought in, Heather or John, whoever.
I don't have him on Zoom, Judge, so I'm not sure if he's here in person.
You wrote here, John.
He's on Zoom.
Do you see him?
No, I do not have him out here.
I got
Oh, you know what? You do, John. You don't have me as a co-host. That's why I don't see him.
Okay. This is again, officer, you can start your video. Kenneth James McKay Jr., 25B 149-883. Your name, sir? Again?
James McKay.
All right, officer, your name?
Officer Gage McParland, Brownstown PD.
All right, do you still wish to continue with your not responsible plea? You wish? Okay, I'm gonna ask you both to raise your right hands. Officer, let me see your hand, please. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
All right, so you've both been sworn in. You can proceed, officer.
Yes, sir. On the day of the incident, which I don't have in front of me right now, unfortunately, I got a call to the area of Huron River Drive, just west of West Jefferson for an accident. When I arrived on scene, I seen two people pulled over to the side. One individual said that he was attempting to turn left to a private drive, and that Mr. McKay was impatient and went around him at the time he was turning, and unfortunately, the two collided.
All right. So is the alleged victim here traveling eastbound or westbound?
He was traveling westbound, sir. Both parties were traveling westbound.
Both were traveling westbound, so the defendant was going to, I'm sorry, the individual with whom Mr. McKay was involved in an accident with was going to turn left onto southbound here on River Drive. Is that true?
He was going to turn southbound, but it was into a private drive, Your Honor.
I got it. I'm sorry. I misspoke, really. And then Mr. McKay was driving westbound as well. And there was a collision in what? The eastbound lane of Huron River Drive?
Affirm, sir.
I'm sorry.
Yes.
Do you have any questions for him, sir?
Yes, I just want to confirm that you recall driving eastbound and then making a 3 or 4 point turn to turn around to tell us both to proceed forward and then turn left onto the side street there.
Are you talking about after the accident?
Correct, yeah, when he got there.
Yeah, I told him to turn down a side street over there. Correct.
So you could investigate the accident?
Yeah, and get him off the road right there.
Right. Okay. What other questions?
I don't have any other questions for him, just the defense in the video that showed there was no.
Do you have a video?
I do.
Where's?
I don't have a video of the accident. I have a video of directly afterwards that shows his cruiser there and the other vehicle there to show that it was the day this happened. There was no debris on the road. There was no yaw marks. This was a very low speed collision. The other vehicle actually turned left and hit the side of my car. I was already alongside this person. This happened in a passing zone. He was stopped in the middle of the road with no turn signals on. I am a professional driver. I was in a Ford Focus that is very low to the ground. He was in a Ram pickup truck. His taillights were in my face.
Wait a minute, slow down. So you're traveling west behind him. How far are you behind him? Initially, before you decided to pass?
Close. He was going slow. He was going dangerously slow for that area.
What do you mean dangerously slow for that area?
So if you're heading southbound on Jefferson, you go around on the Current River Drive, there's a turn road.
Right.
And people go around that road 45 miles an hour. And he was going maybe 5 or 10 miles an hour. And people come around that road, and I was afraid of getting rear-ended. And then he proceeded to go slow. And
What do you mean you were afraid of being rear-ended by who? Was somebody behind you? Okay, but so you decided to pass?
Yes, the passing zone, I decided to pass. Because there was no turn signals on this vehicle. I was under the impression that maybe he was irritated that I was there because he was going so slow. So I went to pass and I got alongside him and he turned into me. The damage on my vehicle shows that he also turned in.
All right, slow down a second. Were there any injuries here, officer?
And Your Honor, I do have something else to say whenever you guys are free.
No, I know, but I want to ask you that question first. Were there any injuries?
No injuries, Your Honor.
And was there serious property damage to the other vehicle?
No, sir.
And you don't want impeding traffic?
No.
Okay. All right, what do you want to add, officer?
On Huron River Drive, just west of where the accident did occur, I went back and I investigated that area. It's a permanent yellow line, which you're not allowed to pass. And I know the accidents happened there because the victim driver said, hey, it happened over there. And there's a solid double yellow line over there and you can't pass. So I said, okay, I'll go back and investigate. So I did go back and investigate that area. And the accident did happen there because there was very minor debris on the road. And there were clear yaw marks where the individual, Mr. McKay, clearly tried to go around where the victim said it happened. So there were tire marks in the lane. So he was not supposed to pass in that area, but he still did. And that was the area that
That's why you wrote him for improper lane use.
Yes, sir.
I disagree. I have video that shows no yaw marks and also.
If you want to show me any video, I have no issue with that. I'll be glad to look at it. I'm not sure that if it doesn't show me where if it doesn't depict the accident,
Well, it shows where I was pulled over because you can see my tires, because I went on the shoulder. The other vehicle did not go on the shoulder. I went to the shoulder after the
I'll
accident.
be happy to look at whatever you want.
Take me just one moment to find it. How do I get it to you?
You can hand me your phone. You can't see this though, can you, officer?
So.
Unfortunately not, Your Honor.
The problem is you may have. to
Can we
play-
get that up there? Would it be hard?
I don't know, it's just, you have to be Shane. Call Shane.
Yeah, see if he can do that real quick.
You come in and judge downstairs.
Hmm.
I have a suspicion that the marks that he was seeing or possibly where he arrived on the scene, he turned around because I can see all the marks in this video. And also where somebody backed out of the driveway.
I think what he was telling me is that the debris was in the zone that was a no passing zone. Is that not what you're telling me?
There was nothing missing from my vehicle. I don't know what could have been missing from his vehicle. His tire hit my car. There was nothing missing from my vehicle. Zero debris, zero breakage. I have video of the vehicle as well.
Do you have vehicle of the area where the impact occurred?
Yes, I do. Where I believe it occurred due to the marks on the pavement. So what happened when he turned into me, there was a Dodge Ram pickup, like I said, he turned into me and his tire hit the right side of the car and it knocked the toe in on his vehicle. And you can see where he pulled away. You can see where the yaw marks are from the toe in his truck.
Was there any indication as to whether or not he had his turn signals on, officer?
Mr. McKay said that's what happened. When I asked the victim driver what happened, he says he did have his turn signal on and that Mr. McKay was impatient and went around him because he was going too slow. And then the reason for them pulling up, hold on a second, Mr. McKay. The reason for them pulling up is because where the accident occurred, according to the victim, there's also another lane that kind of comes diagonal from southbound West Jefferson. So they had to get out of that area. So they all pulled up more westbound on here on River Drive because you don't want to be kind of caught in that area, that intersection area where the victim driver said the accident occurred.
Which is precisely why I was trying to pass this person because it's a dangerous area. And as the officer stated, the driver.
Hang on one second. Can you get that up on the screen?
Shane said he's gonna have to zoom in.
You're gonna have to zoom in on your phone and share your.
Yeah, I don't know how to do it. So I'm a very simple person.
Or you can show your phone.
Let me see it.
You can see it.
Let me see it though. Let me see it.
I don't know. You're gonna have to play it again and again. I just explained to you the video. It shows where the double yellow ends.
Just hand it to me. Let me take a look. I can't see a thing from where you
It's
are.
very clear that there's no.
You zoom in.
Yeah, and it's fine.
At the very end of the video, I can see the officer's cruiser pulling away towards me. And at the end of the video on the right,
Thanks, Sean.
is where my tire track is, where I pull away. Onto the.
What am I looking at now? I'm seeing a car.
I don't, because I can't see.
Well, I'm looking at a car. Is that from your vehicle,
That's-
right? Well, what, this is after the accident, right?
Yes, that's correct. I had to document the area in order to.
I'm not sure why I'm looking at this. Why am I looking at this if it was after the accident?
Show you that number one, there's no debris. Number two, the tire tracks that are seen are from people backing out of their driveways or when the officer arrives, his 4-point turn, he did.
Can you have this put up there? I want this officer.
I don't know how to do it, Judge. He's gonna have to zoom in with your Zoom
You
ID.
can Zoom with my Zoom ID and we'll get it on the docket here. Just be patient with me, officer, please. Okay, I'll be right with you.
No problem, Your Honor.
Kimberly Ann Rose. Somebody can help you.
Yeah, I'll send him to the right person.
25T647291. Good morning, ma'am. Your name? You're charged with driving on a suspended license and you have the right to a lawyer. Would you like an attorney?
Yeah.
Okay. We're going to give you an attorney. You go out in the hallway, your lawyer will talk to the prosecutor, and then you'll come back in front of me, okay? You're welcome. Good no. Darren Michael Goodnow, 25T647391. I have A, B, and C. I have an unauthorized or improper use of lights, no insurance, and driving on a suspended. Your name?
No.
All right, so you are here for arraignment and pretrial. You're charged with a misdemeanor, drive while suspended, 2 civil infractions. You have the right to a lawyer. Would you like one? I'm sorry? I'll go ahead and arraign you. I'll send you to the prosecutor then, okay? It is alleged that on December the 26th of 25, that you were operating a motor vehicle in the city of Trenton. And they think that you did not have a valid license, that it was suspended. They think you were driving on Grange West in Trenton at 8:10 PM on that date. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs of all those, and 2 points. Do you understand that? You also have 2 other charges, no proof of insurance and unauthorized or improper use of lights. Do you understand that? And did you sign, read, and understand an advice of rights form here today? If you plead guilty, you will be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes, sir.
You still wish to waive your right to a lawyer. I'm entering a not guilty plea. $500 personal bond. You don't have to post any money.
I have
Hang on. You don't have to post any money, but you cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You understand that? All right. So you go out in the hallway. He'll call you in momentarily. All right. Funchess. Kiamora Rain Funchess, 25B 1499618 and B. Do you have any more files down there? Funchess, is she out on Zoom?
She's on Zoom, Judge.
Okay. Your name, ma'am?
More Funchess.
You're charged with driving while unlicensed, and you also have a civil infraction, a failure to yield. You have the right to a lawyer. Would you like a lawyer?
Yes.
All right, you just stay put. I'll be with you momentarily. We'll put you in a waiting room, and then as soon as they're ready, they'll zoom in and talk to you. Okay, so this one wants a lawyer, John, and they do not.
This one going to.
That is just going to waived attorney, so that's going right to the prosecutor. And then this one is this young lady right here. She's on Zoom, and she wants a lawyer. Eric Anthony Schilling, 25G 306772. Your name, sir?
Eric Schilling.
Good morning to you. You have a charge. You met with a department rep. You're going to plead to impeding traffic, right?
Yes, Your Honor.
To that charge, responsible or not responsible?
Responsible.
All right, I'm going to accept the plea. $160. You can go down the hall and make your payment, okay?
Yes, sir. Thank you.
The speeding is dismissed. Good luck. Happy New Year. Murphy Holding LLC, 25P 647-033A. And I also have, give me 1 second here. I have 647-033A, B, C, and then I also have 647-037, A and B.
Good morning.
Good morning, Mr. Gunner.
Good to see you.
You too.
Yeah, I think they wrote the same ticket twice. I was talking to the prosecutor about.
I need your appearance first.
I'm in please the court, Patrick Gutner, P 70106, appearing on behalf of the defendant, Murphy Holdings LLC, who's representing Christopher Murphy's here to be detained.
Let me call him, man. I can't even make heads or tails out of this, what he's written up here. Okay, sir, your name?
Chris Murphy.
All right, so first of all, he has a charge of commercial vehicle, no plate. Does he stand mute, waive formal reading on that charge?
Yes.
I'm gonna need you in here, Mr. Bologna, please.
Oh, yeah, okay.
Thank you. Same thing on file C, the insecure load.
Yes.
All right, so those are the 2 misdemeanors I have. Now I have 3 civil infractions. I have a safety equipment, flares, no medical waiver card. Hang on a second. Yeah, I have safety equipment, violation flares. I have no medical waiver card. That's just. I'm having a hard time making heads or tails out of this one, Mr. Bologna. Then I have a B, well, it's not your fault. I have a B file, no insurance. So I have 647033 that has no trailer plate, commercial vehicle, no proof of insurance, commercial vehicle, an insecure load, commercial vehicle. Then I have on 7037A, which is the same offense date, I have a warning on the operating without a proper endorsement. And I have safety equipment violation, flares / triangles, and no medical waiver card. So I want to make sure that I'm doing this right. So first of all, you've got improper display down here. What file is that on?
We're amending the charge here. We're adding.
Yeah, I know, but you got 5 cases
That
here.
would be on the plate violation of misdemeanor.
The 3-3 case.
Is that the A file or is that the B file? That's the A file. All right, so you're dismissing the original charge, no trailer plate, and he's pleading to improper display, right?
Correct.
Yes.
All right, let me just take one of these at a time. All right, so I understand that one. Now we've got, you got a B and C case here on 7033A. Am I right that he's pleading to no proof of insurance on that one? And he's also, that's file B, and he's also pleading on 647037A,
Safety.
the safety equipment, is that right?
That's correct.
That's correct.
Give me 1 second. All right. And then I've got, you're dismissing the no medical waiver code, right?
Correct.
Why didn't your client show up first? He wasn't here, was he? Maybe, I don't know why we entered a default judgment on December 4th. All right, dismissed for STIP, that's on no medical waiver card. And then what am I doing with the last file? You got, I think you only have 4 written up here. He's also got a, so I've got him pleading as charged on 7037A, pleading as charged on 7033B. 7037B is being dismissed. He's pleading to improper display on 703A, and I don't think you did anything on the insecure load.
That's a dismissal.
That's a dismissal? Okay, you got CMV load, I see now. All right, do you understand all of this, sir?
Yes, sir.
Okay, so to the charge of improper display of plate, responsible or not responsible?
Responsible.
To the charge of no proof of insurance on behalf of the company. What's your position, by the way?
Woman.
So you're the president?
Yes.
So to the charge of safety equipment violation on behalf of the company, file 7037A, responsible or not responsible?
Responsible.
And to 7033B, no proof of insurance, responsible or not responsible?
I think what the government needs to know about, it's still valid. I think so.
Yes.
Yeah, so I think there was a plea on that one, Your Honor, to Friday, it's been valid, and he'll.
No, he's pleading to no proof of insurance according to this.
I think that was actually amended to unable to display valid proof of insurance.
It's the same.
Well, what's the same?
Yeah, I think it's the same.
Same charge. It's no proof of insurance.
Okay.
They didn't charge him with a misdemeanor of no insurance.
Yeah. It's just a over, yeah.
So to that charge, no proof of insurance, responsible or not responsible? To improper display again, responsible or not responsible? Just violation of, the safety regulations on file A, responsible or not responsible? All right, good enough. Give me 1 second here.
Thank you.
Just a little confusing. Oh. Does he have insurance now?
Yes.
You can't be driving a commercial vehicle without insurance, sir. Right? All right. On the, no insurance. They didn't write that one as a commercial. I'm doing, or $200 on that, on the improper display, 210, and on the, defective equipment or safety violation, I should say, 235. So he owes 235, 435, 645. Can he pay all that today?
Yes,
All right, Mr. Gunner, good to see you. You doing all right?
Judge,
Yeah.
can I ask, what file was the improper plate? I'm sorry, that was a lot. I was trying to keep up.
I know. I know it was on the note 7033A, he's pleading to improper display,
Okay,
and they're dismissing the no trailer plate.
okay,
So they're dismissing the misdemeanor. He's pleading to a civil infraction of improper display. On 7033C, which is unsecure load, they're dismissing that. On 7033B, he's pleading to that, no proof of insurance. On 7037A, he's pleading to that, which is, safety equipment,
Safety
flares,
equipment, yeah.
triangles. And then they're dismissing 7037B, which is no medical waiver card.
okay, thank you.
Okay, no problem. You're all set. Have a good day. Happy New Year. All right. Phone has to go out of the building, man. Thank you. Misha, Adina, Tokashir. I don't even see which one you have, Mr. Osmond. Your appearance, counsel?
Your Honor, good morning. Nader Nassif appearing on behalf of Ms. Tolkachir.
All right, so this is going to be a plea to impeding traffic, and the speeding is going to be dismissed, true?
That's correct, Judge.
All right, you're authorized to enter that plea on his behalf
Yes, Your Honor.
to the charge of impeding traffic, responsible or not responsible?
Responsible.
All right, I'll accept the plea. 150 is the total, and I am going to give him until the 22nd to pay this, okay?
Okay.
He can go right on 33court.com.
All right.
All right, have a good day.
Thank you, Judge. Have a great day.
I don't know which one you have, Mr. Osmond. Did you talk to the prosecutor?
No, I have City of Trenton versus Stevens disposal set for 8:45 this morning, and I've been waiting to be put in the room.
I'm sorry. Can somebody put
Mr.
him in?
Osmond, yeah, I put him in there. I thought you spoke with him because it shows you were in there and I thought you came back out. I apologize.
No,
That's
Yeah,
all
it
right.
shows that you
You
were in
don't
there.
mind
Okay, let me
sitting
do
here and learning something for a while, do you, Mr. Osmond?
I'm always willing to learn from you, that's for sure.
All right, just wait 1 second. We'll get you in there. I'm sorry about that. Sir, just wait till he comes back and then you check in with the court officer, okay? I mean, you're fine standing there until he comes back.
Oh.
All right, people against Jamie Joseph Perilla, 25G 306-687. All right, good morning to you. Your name, sir? Jamie Joseph Perilla. Let me see here. All right, so you met with the department rep and you were going, come on up to the podium. That's all right. You're going to plead to impeding traffic, right?
Yes.
That's what you want to do?
Yes.
To that charge, responsible or not responsible? I'll accept your plea. I'm going to dismiss the speeding. Let me see. You got a good record?
Yeah.
All right, 150. Cashier end of the hall to your right.
Can I get that right now?
Yeah, you're all done.
Thank you.
Be careful out on the snow. Good luck. Lester Douglas Wood. 25G 306-709. Come on up to the podium, sir. Good morning.
Good morning to you.
Your name?
Lester Douglas Wood.
How you doing today? How you doing today?
I'm doing good. So far, you know.
I know, it's only 9:45. There's a lot that could go wrong. Okay? There's a lot that can go right though, too. So let's be optimistic. You're gonna plead to impeding, right? Is that what you're gonna do?
Well, I'm hard of hearing.
I'm sorry. You're gonna plead responsible to impeding traffic, right?
I am.
To that charge, responsible or not responsible?
I am responsible.
Please accepted, speeds dismissed 150. Cash your end of the hall to your right. Happy New Year, good luck.
Yeah, yeah.
Thank you.
Very good. Thank you.
You're welcome. Do I have something with you, Detective Driscoll?
Good morning, Your Honor. We had Teresa Riddle from yesterday. I just kind of zoomed in to see if you needed anything to questions answered, and we had some information we wanted to provide.
Where's she at now?
She made bond, Judge. I do not know where her whereabouts are.
What time did I set that?
8:30.
What do you think the odds are? You want to take a bet on lunch or
We had
something as to whether or
a-
not she's gonna show up? It's 9:45 and she has this uncanny ability to fail to show up.
If I were a betting man, I would not be pulling for Miss Riddle on this.
All right, you know what? You can tell she's missed on this case before.
Yep.
You can go ahead and call or whatever. I'll tell the prosecutor to just send in the file and issue a warrant again. This is ridiculous. She already forfeited a bond once on this. Let me just call him real quick and then I can get you out of here, okay?
Very good, Judge. Thank you.
Sergeant Driscoll's out here and Ms. Little failed to favor us with her presence today again, so it was scheduled for 8:30. It's now 9:47. That's enough time. He told Mr. Bologna he can send in a request for a warrant. She's missed before on this. Okay? Thank you. Thank you. So you can go now or you can go later, whatever you want. I'm just gonna have him bring it and issue the warrant. Wow. People give us, I don't understand that. Thought 500 was enough.
Miss Riddle has a habit of not showing up, Judge.
No.
Okay, I appreciate it. I see you got a pretty decent docket going.
Have a great day.
Thanks,
you.
Judge. Bye.
Okay, how we coming on Mr. McKay's Zoom?
I believe this is his phone out here, Judge, that says Kenny's phone. I'm pretty sure that's.
Well, then
his
are we
phone.
gonna zoom it on? Are we gonna be able to put it on the
I think he
screen?
can phone share. He can share screen off
I hate
his
it.
phone from there.
Do you know how to do that?
If
He
he
has no
turns
clue.
his
Neither
video
do I.
on, if he turns his video on, there'll be an option if he taps his screen that says.
Try it. Turn your phone
share
on,
screen.
please. Mr. McKay, they should have, wow, he's a St. Patrick's baby too, eh?
The officer should be here.
Big one coming up, Mr. McKay. I was gonna say,
It is a big one coming up. I'm on the Zoom, my phone's there.
okay, now what's he gotta do? He's on Zoom. We see Kenny's phone on Zoom.
He has to have his video on.
You have to have your video, so start your video, bottom left-hand corner of your screen. Maybe Ms. McRipley can help. I'm just kidding. I want to talk to you if you get a minute. Thank you.
Sorry.
There
And
you are.
then there
I
should
see-
be, I think if you tap somewhere, there should be a screen share. Trying to think.
Yeah.
Do not help? Sir, come on up here. My secretary, you gotta be under 50 or at least to know all these technology rules, all these technology rules that drive us all crazy, right? Sadie, you're on YouTube now. Okay. All right. Now,
I'll find the video.
Okay, Officer McParland, start your video again. Recalling Kenneth James McKay Jr., 25B149883.
Kids and technology.
I got news for you. He's younger than you are.
This guy?
Yeah.
Of course he is. Like 40.
He looks 10 years younger than you.
Should be still in this. You scroll, with the data, scroll down. Okay.
Yeah, it's showing foolishness.
Yeah,
The
it's-
photos, but not this.
That's where it would be, okay.
It's not there, just the photos.
The Zoom number to me to reach him when and you're in, you're in like a long story. I think we did made other.
It's not giving an option to share the video.
It's not giving an option to share the screen.
No, we can share the screen, it's just not showing.
It's not showing videos. All right. I'm sorry. We tried.
Your Honor.
Yes, you're still under oath, by the way, officer.
Of course, Your Honor. I also have, I'm lucky enough to be off today. I do have a map in front of me so I can better explain to the court too and show you on Google Maps if it's okay with you in the court. To show you how far this yellow line does go, if that's okay with.
Absolutely.
It's very clear on the video how far the yellow line does go. It's very clear where I was stopped on the shoulder.
Okay, just wait. Let me look at what he shows me first, okay?
Of course, Your Honor.
My concern here is, even if you were in a passing zone, I got testimony here that the guy had his turn signal on.
And me, a professional driver, I have driven 500,000.
What do you mean a professional? What do you mean a professional driver? You have a CDL?
Which license I have a transportation company. I am testifying right now that the man's lights were in my face and there was not a turn signal on. I would not have, as a professional driver, I would not have passed this person had there been turn signals on. The officer stated himself that the person felt that I grew impatient and passed him. That proves that he knew I was back there. And I believe that the other person may deny this, that he did it intentionally, that he was going.
Got in an accident intentionally?
They didn't get my car intentionally. He was going dangerously slow. First of all, this was an elderly person. He was looking for a home that he must be unfamiliar with, because that's what he told the officer, that he was going to somebody's workshop there. Must be an address that he's unfamiliar with. That must be why he was going so slow. So I was behind him when it got to the point where I could get around him. I did. It aggravated that person that I was doing that. And he.
Well, you don't think he intentionally slammed into the side of your vehicle, do you really?
I have a suspicion that that was part of the matter. The officer said himself that he thought to that. That the other person thought that.
Okay, you're gonna lose me on that.
Okay, well, that's fine.
All right, go ahead. Show me what you want to show me, officer.
Yes, Your Honor. I'm gonna go ahead and just try to turn the video around. Do you know in the court in the app settings, if that's possible? If not, I'll do my best to go ahead and turn around so I can go ahead and explain it to you on the monitor I have in front of me.
You guys
If
ask
not-
me technology questions and you expect me to know the answer, huh? You should know better.
My apologies, Your Honor. I'll do my best right here. Let me know if you can
Thanks.
see my, Your Honor.
Yeah, I can see it.
All right, Your Honor. So this is West Jefferson.
And you
going
can see it,
northbound.
right?
Yes.
Okay, go ahead.
All right. So as you can see, there's another lane like Mr. McKay and I said that it comes in through here. Okay, so if I just click like this and I go to the street view, here's that lane that comes through here, southbound. Now you see this double yellow?
Yes.
This is where in this area, forgive me, that all the way up to this bridge that the victim driver said the accident happened in. And as Mr. McKay and I previously stated, they both had to get out of this area so that way they wouldn't get hit. You know, they can't just stay right here. So if you go this yellow line, as you can see, it goes down quite a ways. I'm zooming in, zooming in, zooming in, again, until we almost hit a street down here called Ludwig.
How much,
this is-
hang on, slow down. How long would you say? Now, it's hard for me to tell that double yellow line exists there on that roadway. Can you give me an estimate?
As far as yardage, Your Honor?
So you're saying it happened west of there?
It happened well west of there. The tire tracks on my video show exactly where it happened and exactly where my vehicle was stopped on the shoulder.
And
it was nowhere near that area. It was at.
Where were they when you told them to move their vehicles? When you arrived on scene, where were they?
They were in this area between, just past this, they were in this area right here to this area over here. I would say it's about a good, probably 70 yards, Your Honor, 60, 70 yards.
From the end of the double yellow line?
Yeah. No. So from the line over here, which is the double yellow, the ending of it, to where I found them, which is over here.
Over where? Show me.
They pulled up,
Okay.
they were in this area, okay?
All right.
And they said, the individual said the accident happened like in this area right after where that southbound lane, like Mr. McKay and I said. And then I found there's a private drive. I don't know which private drive it was, but there were yaw marks that were like, not 3-point yaw marks. They were yaw marks that go like this around, which clearly show, you know, that someone was trying to go around, not someone pulling out and then going forward.
And you saw debris in that area? Is that where you saw the debris?
Yeah, there was minor debris, Your Honor. And my apologies, I didn't get down and look at like what kind of debris it was and trying to verify which, you know, could have been from another vehicle, of course. But from where the victim vehicle said this happened, I'm certain it was Mr. McKay's vehicle, and it was definitely within the double yellow, and it was clearly double yellow in the area that the accident, the victim said occurred.
All right. What do you want to say?
I want to say, I want to be able to show you frame by frame my video. So I can prove to you where this accident happened.
Where are you going to show it? I got to have.
I have it on my phone, so I don't know. The officer should be here. That's what should happen. The officer should be here.
Well, we don't make them come here. And in fact, if you wanted to do an informal, I let them come here. Where are you now?
Where am I? I'm at my residence, Your Honor.
Yeah, what city?
Judge,
I'm in
what?
Shane said if he emails the video.
Go down and talk to John. You go down to the end and talk to the tech guy and see what we can do. Okay, let's do that. You go down and talk to the tech guy. Go all the way down the hall and they'll bring it up for you. All right. Just bear with me, officer. Teresa Lynn Little, 25T642922. Multiple misses from this young lady. Defendant failed to appear. Bench warrant to issue. Forfeit bond. She keeps failing to show up. This one's going to be 10,000, 10%. And it was scheduled for 8:30 and it's now 9:58. People against Mark Solomon Wesley, 25T647066. John, come here, please.
Ready, John? Yeah, I got it.
Good morning.
Good morning, for the record, James Schlaf, 30720.
All right. How you doing, Mr. Schloff? Your name, sir?
Mark Wesley.
So for purposes of arraignment, does he stand mute and waive formal reading?
He does, Your Honor.
All right. I'm entering a not guilty plea, and then he's going to plead to no proof of insurance.
Yeah.
John. come here. To that charge, no proof of insurance, responsible or not responsible?
Responsible.
Can I ask a question?
Sure.
Also, return insurance, could that be?
Yeah, you get everything. Well, he's pled it to no proof from a misdemeanor. I can't. Okay, I'm gonna charge you 185 unless. Okay,
Just in furtherance, Your Honor, he has cleared up all the outstanding
good,
problems, including he has good insurance now. I presented that to your process.
good. Your total, I'm gonna accept your plea, dismiss the misdemeanor, okay? 185 is your total. Can you pay that today or do you need time? When can you pay it?
Probably closer to
You,
in the next month.
no problem.
2 weeks.
Yeah, I'll make it February the 7th. Is that enough time? Now, listen. I need you to have a seat over there. We got an order from a probate judge that says that they're ordering us to take you into custody in the police department.
Hold on, I didn't finish.
It's over a mental health issue. I'm just telling you, I got an order from a probate judge and I have to do it. We're gonna take you down there. Trenton's gonna come and pick you up and they're gonna take you there, okay? Sir, I can't ignore a judge's order either, okay? I just can't ignore the judge's order. I'm sorry. If you need more time on this, if you get to February 7th and you can't pay, call the court. We'll go on Zoom. I'll give you an extension. I'm sorry, but I have to have you taken into custody. I really am.
I'm gonna ask to take care of another case and then I'll go over and speak to him.
Sure. Thank you.
It's okay.
Yeah, I don't know anything about it. Stevens Disposal. Let me get this, Mr. Osmond, poor guy's been waiting here all morning. 25T647-284 A and B. All right, Mr. Osmond, your appearance.
Yeah, Jeff Osmond on behalf of Stevens Disposal.
All right, so I have an A file. You're going to plead on that. That's over. And then I'm going to go ahead and dismiss. I'm going to go ahead and dismiss the defective equipment. There's agreed upon fines and costs of $1,300. True?
Yes, Your Honor.
To that charge, overweight, you're authorized to enter that plea. True?
Yes, Your Honor.
To that charge of overweight on behalf of the company, responsible or not responsible?
Responsible.
All right, I'll accept the plea. Fines cost $1,300 per the agreement, paid by February 15th. I don't know what happened. Sorry about this. Have a great day, counsel.
You too.
Thank you. Gaddy. Jalen Avery Tyler Gaddy. 25T645-675C. And I don't have an A and a B file.
Because I just think I saw the tickets inside.
See,
Judge, I believe those are paid. There's only one open file. Those
So-
ones look
so-
paid.
call the. See, he already went into default on those a long time ago. I'm gonna give him back. Maybe he'll cut you a better deal. But he really should. Can you come in 1 second, Mr. Bologna? Thanks. So I asked him not to go back. If it's a month old, that's one thing, when the default's entered. But this is 8 months old. So if the ticket isn't, your name?
Anthony Boyd.
If the ticket isn't in here, it's been disposed of. Again, when they get 8 months old, I'm gonna ask you not to set those aside, really. I don't care if you give him a better deal. I don't care what you do on these others. If he's paid the others and you want, that's your choice, but he's already been in default. Licenses get suspended. I don't want to make a mockery. So I'm going to hand you this back. You talk to Mr. Schloff again. Mr. Gaddy, you have a seat. Your lawyer will be in touch with you, okay? Thanks. Kimberly Ann Rose, 25T647-291. All right. Good morning, counsel. How are you?
Good morning, Your Honor. I'm doing well. How are you?
Not too bad. Thanks. Ma'am, your name,
Kimberly Ann.
your appearance?
Peter Donata, P78413, MIDC counsel.
For purposes of arraignment, she stands mute, waives formal reading. True?
Yes, Your
I'm entering a not guilty plea. Now she's going to plead to no ops on person, a 0-point violation, ma'am. And then I'm going to go ahead and dismiss the suspend on motion of the prosecutor. The no ops is punishable by up to 100 fines, 90 days jail, costs, or all of those penalties. Do you understand that?
Yeah.
You just sign an advice of rights form here today. Did you read it and understand it? If you plead guilty, you'll be giving up all those rights. And there's not going to be a trial of any kind. Do you understand that?
Yeah.
Did the charge no valid operator's license on person? How do you plead?
Guilty.
Were you operating a motor vehicle? December 9 to 25 on Fort near Emmeline and Trenton at 7:32 in the morning.
Yeah.
Did you have a valid license on your person?
No.
Are you on probation?
No.
Parole?
No.
Anybody force you to plead guilty?
No.
Please accept it, suspends, dismissed. I'm ready for sentence. She doesn't have a valid license yet, right?
No, Your Honor, she has a couple of tickets she has to clear up in a different jurisdiction, and then she should be able to get her license back. There are only tickets, outstanding tickets. But I would like to ask the court to consider the fact that Miss Rose is on disability. She's supporting two young children, 10-year-old children, and in some cases her grandchildren, only on.
How do you have 10 years? You have 10-year-olds?
Yeah, 10-year-old and a 14-year-old.
Those are your children.
So based on the fact that she's very low income and has that obligation to support her children, I would ask the court to consider either a waiving the cost of fines or a lower cost of fines, and if so, possibly a payment plan.
Is the husband in there? Is the father in their lives?
Yes,
Does he pay child support?
Yes.
Does he live with you?
not really.
Okay, I can.
I was in an abusive relationship with him. He was-
All right. Anything else you want to say?
No.
I'll cut the fines down a little, but you got to get a valid license, okay? 100 fines, 50 costs, 75 victims' rights, $50 justice assessment, 275 or 60 days. How much can you pay today?
Can I sell the peanut? Right?
Yeah, can you pay anything today? How much you get in disability?
1,000.
Can you pay 75 a month?
Yeah.
You pay 75 per month, and we'll start this beginning February 7th. And if you don't have the money at any point,
I will get it on the 3rd.
well, I'm giving you till the 7th. If you don't have the money, though, you call the court, we'll go on Zoom, or you can walk in here on or before any of your payment due dates, and I'll be more than happy to give you an extension. Just don't ignore me. That's the only thing, okay?
Thank you.
Have a good day. Thanks, counsel. People against Dennis Wayne Wingle, 25T647294. Mr. Wingle, come on up here, sir. You tell me your name, please.
Dennis Wayne.
You're going to plead to no ops now, right? You've met with the prosecutor. He's going to dismiss the suspend, true?
True.
If you plead to this charge, the possible penalties are up to $100 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
You plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes, sir.
You still wish to waive your right to a lawyer?
Yes, sir.
To the charge, no valid operator's license on person, how do you plead?
Guilty.
Were you operating a motor vehicle on December 10 of 25 at 7:26 in the morning on Fort near King and Trent?
Yes, sir.
Did you have a valid license at that time on your person?
No, sir.
Are you on probation or parole?
No, sir.
Anybody in the world force you to plead guilty?
No, sir.
Please accept it. You're revoked. You got to go back and get a license, sir. I can't let you drive on a revoked license. You've had 4 drunk drivings, right?
Correct.
Come on, what are you doing? You got to go talk to a lawyer. You can't drive. Where do you work at?
I work a lot of different places.
What do you do for a living?
I build homes. Construction.
I don't know what to tell you, Mr. Wingo. You seem like a nice man, but you can't be driving around on a revoked, okay? All right. What else? Anything else?
No, that's
Just don't come back here, okay, please? 100 fines, 175 costs, 75 victims' rights, $50 justice assessment, 493 days. Do you have that to pay today?
I have some.
How much?
I have to check my card to see how much I have.
How much you think you have?
At least $100.
You pay 100 now? Can you pay 75 per week or not?
Yes.
I'll make it 70. You sure? I'll make it $60 per week, and I'll give you a little leeway time. We won't start this until the 30th of January. If you ever need more time, no problem. Call the court. We'll go on Zoom on or before any due date where you don't have the money, or come in here on or before the due date. I'll give you an extension. I'll promise you. I don't care how many times we have to do that, but don't ignore me. Okay?
Yes, sir.
All right. Best of luck. Have a nice year. You go right down to the cashier into the hall to your right, make your $100 payment. Best of luck to you.
Judge,
Yeah.
Zoom cut out on that. What was his payment plan? He's paying 100 today?
Yeah. And then he's going to pay starting January 30th, he's gonna pay $60 per week, 60 per week, starting January 30th.
Thank you.
Thank you. You have Gaddy?
Yes, I do.
Jalen Gaddy, 25T645675C. The other ones have been taken care of.
That's right, Your Honor. We discussed that.
Okay, could I have your appearances, please?
James Schlaf, 30720.
All right, and sir, your name again?
Then, yeah,
So just to be clear, he paid the no proof of insurance in the speeding. Is that what you did already?
yes, sir.
So he's gonna plead the no ops. The possible penalties are up to 100 fines, 90 days jail, costs are all those. If you pay that, I'm gonna go ahead and dismiss the suspend.
Thank you.
If you plead to that, I should say. Do you understand that? And did you sign, read, and understand an advice to rights form here today?
Yes,
If you plead guilty, you'll be giving up all those rights and we're not gonna have a trial. Do you understand that?
yes, Your Honor.
To the charge of no valid ops on person, how do you plead?
Yeah.
Were you operating a motor vehicle May the 14th of 25 in the city of Trenton, county of Wayne on Grange near Pine Tree at 5:10 PM?
Yes,
Did you have a valid operator's license on your person?
no, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody forced you to plead guilty?
No, Your Honor.
Please accept it, suspends, dismiss. You have 1, 2, 3, 4. When are you gonna go take care of your 5 warrants? You got all of them out of Detroit, 1 out of Plymouth, another out of Plymouth. So you got 3 out of Detroit, 2 out of Plymouth. You gotta go take care of those, okay?
Yes, Your Honor.
Where does he work at?
I work at Maiden Florida as a flower merchant.
Anything you wanna say?
No,
I'm gonna go light. Anything?
no, Your Honor.
Since you paid the other 2, I'll just make a note. He paid A and B files. 20 costs, 20 fines, 75 victims' rights, $50 justice assessment, 165 or 30 days. Do you have all that to pay or you need time?
May I have 2 weeks, Your Honor?
I'll give you until January 30. If you don't have the money, you call the court, we'll go on Zoom. I'll give you an extension, okay?
Thank you, Your Honor.
Or come in here, on or before due date. I don't care how many times we have to do that. Good luck. Amy Marie Paul, thanks, Mr. Sloff. Amy Marie Powell, 25G306785A and B. Defendant failed to appear. She is responsible as charged by the fault. Case was scheduled for 9:15. It's now 10:12. All right. Heather, do you know how Shane's coming with that video?
I do not. I can check though, Judge.
Okay. If he needs more time, no problem.
Okay.
He's on my docket today.
Judge, he's still
Yeah.
waiting for the video to come through from Mr. McKay.
You have to send it to him.
I've been trying repeatedly. It's a large file. I don't think it's.
Okay, it might just take a minute then.
I just tried something else called mail drop. I don't know what that is.
Judge, I'm gonna try to we have a Galaxy out here that I need to get a name on real quick.
Galaxy A13G. We can't tell who you are when you just put your phone on there. Tell me what your name is, and you're gonna have to change your identifying information from Galaxy to your name. What's your name, ma'am or sir? I can't see you. Start your video and tell me your name, please. You have to start your video, please. There you go. Your name?
Okay. James Martin.
James Martin.
Let me take a look and see what we have him for today. Oh, he's
I
a
have
show
probation
cause.
violation with him, I believe, Sadie.
Yeah, it looks like a show cause today. And then we also have Monroe County jail here with Mr. McCarroll for a 10:15 hearing.
Okay, McCarroll.
Royce McCarroll, yes.
Okay, so James Martin, I'm gonna need, and Carol. Martin's the one that I was talking to you about. Do you have that or is this Jim? Susan Lynn Wolf? 25G 3067848 and B. Good morning, ma'am. Your name? All right, so they're gonna use, they say you have a valid plate. They're gonna go ahead and dismiss. They're gonna dismiss the expired plate. They say you have a valid plate now, and you are going to plead responsible on file A to impeding with the understanding that they will then move to dismiss the speed. True?
I close it in. I don't understand what's in anything.
Okay, well,
Just know that I was having
let me slow down, man. Let me slow down. You have two charges. You have speeding and you have expired plate. They're offering you to plead to impeding traffic, which is no points. And it won't go on your record. If you plead to that, they're going to dismiss the speeding charge and the expired plate charge. Do you understand that?
No.
What part don't you understand? They're offering you to plead to impeding traffic.
I've got to close it entry. And I'm not understanding much of what you're saying.
Okay,
I just know that I didn't know that I had a medical crisis at the time.
hang on. I want to make sure you understand before we go on. They're going to offer you the opportunity to plead to a 0-point violation. It's not going on your traffic record.
I have no money.
Ma'am, you can fight the ticket if you want. I can't solve that issue for you. I'm not going to, if you don't understand, I'll just set it for hearing on both charges and we'll have a hearing. I don't know what more I can do. They're telling you if you plead to impeding, it's 0 points. It won't go on your traffic record and the speeding charge will be dismissed. Do you want to plead to this first? Do you want to plead to impeding?
No.
What do you want to do?
I want to do.
Ma'am, you're not going to get argumentative with me now, are you? You're not going to get argumentative with me now, are you?
Don't know. I don't understand
What part don't you understand?
much of any of this.
Well, that's easy to say. I mean, I don't understand what's going on in the world now either. And I get that.
I was lost in.
Ma'am, you can set it for hearing if you want. I can tell this is going to be one of these where you don't want to plead and you want them to dismiss it and they're not willing to dismiss it. You're either going to have to plead to impeding or set them both for hearing. That's the best I can do. I will work with you on the payments. I don't intend to lock you up.
I don't have money.
Ma'am, I'm not talking about the money here. I'm not talking
I
about.
gotta go to jail because I don't have the money.
So you understand what's going on. You just want to quarrel with me, right? You want to argue with me, right?
No, I just don't have money.
Ma'am, if you want me to set these for hearing, I will set them for hearing. If you want to plead to impeding traffic,
No.
you don't want to plead to impeding traffic. Well, why don't you sit down and think about it? I got all these people with,
Ain't gonna help. I'm still gonna have a head injury.
ma'am, you want to argue with me, huh? I don't need to argue, and I'm not arguing with people. If somebody wants me to argue with them, they can pay me a lot more than the state's paying me. I'm not going to argue with you. Have a seat, have a seat, have a seat. And that's what I'm going to do. That's Susan.
Amy Powers.
Have a seat and I'll be back with you. You think about what you want to do. Okay? What's that?
Amy Powers, if you got it on your bunch.
I didn't think.
Ma'am, settle down, please. You don't get to outburst like that. I can't explain it any better than I have. You want to argue with me. People want to argue with me, detectives, sometimes. You know that, Mr. Swaff? I don't understand it. They want to argue with you. Like I'm the guy who got them in trouble. I'm the guy who was pressing the accelerator. I'm ridiculous. I need, McCarroll, Royce Aaron McCarroll. 24F242579. Mr. McCarroll, your name.
Royce Aaron McCarroll.
You're charged with failure to pay. Did we give him a lawyer? How long have you been in there, Mr. McCarroll?
Since October 29th of last year.
But you're getting out in 2 weeks, right?
Yes, sir.
Why haven't you paid this?
What is the ticket?
It's a suspend charge from 2024. I gave you time to pay. I told you to come talk to me if you didn't have the money. You still didn't do either one of those things.
And what is this court out of?
We are in the city of Woodhaven, County of Wayne, south portion of the county, not far from Monroe, where you are, about 25 minutes, 23 minutes. I can just give you an extension on time to pay. What are you in custody for?
What is it? R&O?
You don't remember, huh?
Yeah, I don't. Yeah, I'm sorry. I don't.
Mr. McCarroll. Mr. McCarroll, how old are you, sir?
29.
How long? You got a record, don't you?
A little bit.
A little bit. Why are you doing this to yourself? Look, I'll tell you what. I'm gonna cut this short. I'm simply gonna give you credit for time served, and I'm closing the case.
Thank you.
Close the case, but please grow up. Don't stop doing this, will you please?
Yes, sir.
All right, have a good day. Do we have Mr. Martin's file? John, give that to whoever is doing that today. Probation. He's sitting here. It's a probation violation, and it's for failure to do 80 hours of community service.
Judge, we have Shane coming in with the video on Zoom.
What's that? It's not going to work?
It goes through Shane. I just left it on there and it hasn't gone through. How do we have Shane that went through? Didn't they go through?
Yeah, anytime he wants me to play it, it's. What do you want me to give him to?
Whatever you want him to play it, he's ready.
You could give it another shot. Okay, recalling Kenneth James McKay Jr., 250-149-883. Officer McParlin, your name again?
Officer McKay McParlin, Brownstown PD.
All right, start your video. Mr. McKay, your name again? All right, you're both still under oath. We're going to play the video, and you can tell me to stop it. Shane, will you stay there, please, and stop it but keep your voice up if you need me to stop it for any reason. And as the vehicle's traveling, feel free to tell me where you were, where the accident happened, any other important points you choose to bring up to the court. You can go ahead, I think, and start that now.
This is the day of the accident, the day it happened. We're gonna do a video here. Here's the yield. Yielded for the person.
This was a different day, right?
This is the
officer
exact
sniffed
day.
his keys.
So the double yellow pens, right
There are no swerve marks
there. There's back out marks right there. Oh,
I saw where it
okay,
ended.
there's back out. So it's really hard without me being in control to show you things. At the very end of the video, you can see off the right shoulder, there's a wet tire mark on the pavement, and that's where I pulled off, where the officer had me pull off the shoulder. So that's how far down I went.
Officer, what kind of debris did you find on the scene?
I can't remember offhand, Your Honor. It was just minor debris. Like I said, I didn't get down and look at it and see if it was like, it was just minor. I can't really just describe it, Your Honor. If it pleases the court too, I have video footage as far as the body camera and stuff. Not with me. If we wanted to set another day, I have it. It was clear day where this accident occurred at.
Play this video again, Shane.
This is the day of the accident, the day it happened.
You need him to stop. Tell him stop.
We're gonna do a video here. Here's the yield. Yielded for the person. here. The officer says he sees swerve marks. There are no swerve marks anywhere.
Up, Shane.
So over there on, looking at the screen to the left is where there are marks from somebody pulling out of the driveway and leaving. That may be the marks that he saw, but as you can see, there's clearly no debris anywhere at all. Because it was,
What time was the accident at?
I guess, yeah, I don't know the exact time.
What time was it, officer? What time did you respond? It says 2:38 PM, right?
It was sometime in the early afternoon, Your Honor. I don't have that document in front of me today. It's one of the
What
only
time
days.
did you drive here?
Oh, you can see the officer.
I'm asking you what time you drove, you created this video.
It was just after the officer relieved me from the scene. At the end of this video, you can see the officer's cruiser pulling away and the other vehicle parked down the road. So if you pause the video right before the end, that's where you can see my tire marks pulling away from where the officer had me pull away.
You want him to keep going on the video?
Yes.
Keep going, Shane, please. Pause. Back up a little bit if you can, Shane.
If you go to the end and like 1 second from the end of the video.
1 second to the end of the video he wants, Shane.
There's the officer's cruiser.
Okay.
My pickup truck is in the distance. It's difficult to see there. It's on the left line.
That's the other vehicle involved?
That is correct. And if you go forward a little bit more and pause it, you can see my tire track. You can see the dot of the dash line, first of all.
Go ahead and go a little bit further, but give me about a second up there.
Right there on the right is my tire track from leaving the scene to go to where the officer had me parked. Correct.
You talk about the one that's traveling, that's
That's correct.
right in front of the vehicle now. Oh, you mean that one over there, you're saying?
Yes. Where.
And then, Your Honor, if I may, in that video, I'm trying to zoom in on my, that's still double yellow right there. Am I correct?
It is not.
I don't think so.
No, that's fine. But I went back and investigated as far as the marks here. And I remember seeing that there were the yaw marks going around the vehicle during the double yellow. So I can't really see on his video very much, but I did go back because the victim was very adamant about me going back where he said the accident occurred at, and there was swerve around marks going southbound.
You want me to see anything else?
Oh no.
You want to what?
He said the victim. He replied, he commented that the other party was a victim.
I can't hear him, Your Honor.
That the other party was a victim. I said, I would like to be a victim.
All right, Mr. McKay, I can tell that you feel strongly about this. Well, you're going to have to appeal then, because I'm sorry. I think that this happened in an improper, there was improper lane use, because I think that I think you did it in double yellow lines. I don't want to argue with you. I've given everybody every opportunity. He went back. He said he saw where the tire marks were. He saw some debris there. The victim pointed it out. I'm sorry. I find you responsible as charged. All you have to do, you drive what? You don't have a CDL, or do you? Well, you got a chauffeur's license, right? Officer, I'm going to give him his choice. If you have an objection, you tell me.
Yep, I'm always willing to drop it down, Your Honor, but you can go ahead.
If you want to plead to impeding, I'll take your plea. It'll be done. If you want to appeal, no problem. Then I'm going to keep this judgment in effect. You'll appeal it. You'll take it to the other judge. Maybe she'll agree with you. It's up to you. It depends if it's a wise guy question, but go ahead. Okay. I'm not going to revisit what my decision was. I want to give you a chance to appeal it. I can tell you feel strongly. Sometimes we think we're right and we're not. I'm doing what I think is right. I might be wrong. I've never said I'm right every time. I'll either let you plead to impeding, in which case you're forfeiting any right to appeal, or you can go down the hall pay the 195, tell him you want to appeal, that will act as a bond and you can go in front of the other judge.
Well, okay.
Okay, so you go down the hall. Heather, make sure that they set up an appeal on a formal 195. Good luck to you. You're welcome. Are you ready, Miss Wolf, or have you not figured out what you're gonna do? And I'm not gonna argue with you. You're either,
Bad head day.
so am I. Come on up here. Susan Lynn Wolf, 25G 306-784 A and B. All right, your name again? So again, I'm gonna ask you, you can either plead to impeding and they'll dismiss the speed and they'll dismiss the expired plate, or you can set them both for hearing.
Okay, but I gotta go to jail because I have no money.
I will give you time to pay.
I'm gonna hold every month.
Ma'am, I don't know what to tell you. I can figure something out, but I'm not waiving your fines. I waive your fines. I gotta waive everybody else's fines.
That's why I wanna go to jail.
I don't want to send you to jail. Do you want to take this deal or do you?
Because of the judge, okay?
You what?
Martin to trial, I was told I would lose because everybody knew that auto owners own Tyrannus. The judge said I wasn't injured in the accident. I'm living on less than $10,000 a year because of that damn judge.
Stop it. Judge Tyrannus was a very, very, very well-respected judge.
He said I
So wait a minute. I'm not talking to you about Judge Tyrannus. I believe he's deceased. I had respect for him when I was a lawyer, and he was a very well-respected judge, and that's not fair. And I have nothing to do with that.
Right.
All right, so you're gonna,
I have no money.
ma'am, I can't.
I need to go to jail because I have no money.
All right, do you want me to set it for hearing or are you gonna plead to impeding?
I have no money. How do I?
Have a seat. You think about it further, but you're not gonna bring up you're not gonna start disparaging a judge, particularly one who's deceased. Have a seat. Have a seat. Have a seat. Have a seat.
Sit down. Don't tell me that damn judge was a good judge.
Ma'am, you come up here 1 second. You want to go to jail, you keep acting like this, but it's not going to take care of your ticket. You are not going to carry on in a courthouse like this. Come here. Come up here.
I'm extremely dizzy at the moment.
Sit down, man. You're not going to disparage a judge. And you're not going to disparage somebody who's deceased.
Gotta close it in.
And Judge Tyrannus was in.
Said it wasn't in.
Well, I gotta tell you, my money would be on Judge Tyrannus's decision because he was a very, very, very good man and a very respectful man. And I'm not talking about it and you're not mentioning his name again. And when you tell me you're ready, I will call your case. All you have to do is raise your hand. I will call your case and I will either set it for hearing or I will take the plea.
I gotta go. I gotta go. I can't be here. I have to go.
Okay.
I gotta go.
Set it for hearing, Heather. Go down the hall and get your notice, ma'am.
Okay, Judge, you just want me to set it for, you
I
want me to
tell
set
you,
it for
there
a
are days
formal
I
or?
wonder. There are just days that I wonder.
Judge,
What
you want me
the
to set that for a formal hearing? or-
Everybody, so many people are so angry now. Wow. Yeah, I know. Zero King. If we set up Mr. Martin with Mr. Schloff, does he know how to get on there? Thank you. Come on up here, Mr. King. Is your lawyer in here or did you?
He went across the hall.
All right. Well, I'll tell you what. I think all of us can use a little recess. We'll take a 5-minute recess and I'll be back momentarily. Everybody stay seated. You can go outside for 5 minutes. Don't make me look for you though, okay?
Okay, yes, Your Honor.
Mr. Martin, go ahead into breakout room 4 and he'll be with you shortly. He's in a breakout room with another defendant at the moment, okay?
Okay, thank
I just want to make sure
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Milligan.
Mr. Milligan, can you state your name, please?
Ryan Joseph Milligan.
Your Honor, I did reach out to the Department of Corrections to try to arrange to meet with Mr. Milligan in person. I was unable to speak with an actual person to make that arrangement.
Got it.
I would ask for a short adjournment, maybe 2 or 3 weeks.
Probable cause conference will be adjourned to February 5th. Yes, sir.
What's going on now? Do I have to see somebody or something?
Yeah, your attorney would like to meet with you. She tried to contact the facility and I guess, if I'm correct, Ms. Gaines couldn't get through to anybody to try to arrange that meeting to talk to you.
So she's gonna come up here? This is like my 4th adjournment, I think.
This will be your last adjournment.
Okay.
Not really. You might be talking about other cases. I think it's your second one.
Well, this will be your last
They
adjournment for this.
rescheduled it for 4 too, but. Okay.
I will make sure I see you.
You'll come up here and see me?
Yes, I will.
Okay, thank you.
You're welcome.
February 5th, 2026, 9 a.m. bound will continue. Thank you.
Thank you.
Thank you, sir. I have a lot on my schedule. Court calls the case, People versus Romeo Smith.
Alex Jablowski for the people.
Michael Gaddy, Assistant Public Defender for Mr. Smith, Your Honor.
See him? Oh, there he is. Mr. Smith, can you state your name, please?
Muhammad Martin Smith.
Thank you. What are we doing?
Your Honor, we have received a competency update. I've had a chance to go over it. I have not been able to see Mr. Smith at the Forensic Center. The report indicates that in their opinion, that he is not competent, but restorable. By my estimation, that date is February 8th.
Pardon?
So by my estimation, I think that restoration date is February 8th.
February 8th?
May we approach, Judge?
Yes, thank you. What do you want me to do? February 5th, 2026, 9 a.m. bond continue.
Thank you, Your Honor.
Court calls the case, People versus Stacy Troon.
Sherilyn Foster Tucker on behalf of Stacy Troon. We should be on the Zoom.
Yes. Ms. Truman, as you can hear us, you need to, if somebody can unmute you. Okay.
Okay.
State your name, please, ma'am.
Stacy Marie Truin.
All right.
And Your Honor, I just received this case, so I just need some time to set up a meeting with her and get discovery.
Where is she?
Gratiot County.
If I give you the 5th, is that going to give you enough time?
That should be fine.
All right. Probable cause conference, February 5th, 2026, 9 a.m. Yes, ma'am?
I go back to court here, January 30th for sentencing,
On which date?
January 30th.
Okay.
Okay.
Are you, it's hard to answer. Are you expected to still be incarcerated then on the 5th?
I'm expected, there's talking about rehab.
Okay, I
and
see.
probation.
Okay, so she may be in around.
Okay, I should be able to get a meeting before the 30th.
All right, fantastic. All right, so I'll adjourn it to the 5th, 9 a.m. bond continued. Thank you.
Thank you.
Your Honor.
RJ. Court calls the case, People versus Trevor Howard.
Alex Jablowski for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Howard. Mr. Howard, state your name for the record, please.
Trevor Howard.
I'm requesting an exam date, please.
Discovery is complete.
To my knowledge, yes.
And our date would be say 27. Thank you. People have their witnesses available to 27.
Yes.
Preliminary examination in person will be set January 27, 2026. 9 a.m. That's before Judge Washington. On continue.
Thank you, Your Honor.
Court calls case People versus Edward Bryan.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning.
Good morning.
The AG can zoom, Your Honor.
No, no, I just can't.
Right.
Stephanie Cannon on behalf of Mr. Byrne.
Didn't Zoom. Sir, can you please state your name?
I thought you said Brian. Your Honor, this is an Attorney General case as
I
well.
know.
Okay.
I have the Attorney General. You're here. I don't have your client saying anything.
He says he's trying, Your Honor.
He's trying what?
To get.
Other than my patients.
No, Your Honor, this is just, it's an adjournment. He has a
Sorry,
meeting.
unmute. Edward Stewart Byrne, Your Honor. Sorry.
Thank you.
I don't want to try your patience, not during.
No, it really is not you. It's your attorney. But
I accept that, Your Honor.
Wow.
yeah, wow. Okay.
Thank you, Judge.
You're welcome.
I think
Your
she's
Honor, we're asking
great.
for an adjournment in this particular matter. I did email the Attorney General yesterday, letting her know this. He is past the 23rd, I believe. He is meeting. He has a FOC hearing to go over his arrearages with the intent on hopefully getting it lowered. So we're just asking for an adjournment past the 23rd.
So he has a meeting with the friend of the court.
Yes.
That's the deal. On the 20.
Friday, the 23rd, January, 10 in the morning.
Okay. And God bless the people at the front of the court. You're probably not going to get an answer that day.
Yeah, I'm suspecting as well, Your Honor.
So I will adjourn this without objection to, why don't we just go to February 12th? At that time, yeah.
212, Your Honor. Thank you so much.
February 12th without objection, 2026, 9 a.m. Bond will continue. Thank you. Is that
Thank
all
you.
for the AG?
Yes.
It is. Madam AG, have a good afternoon or a good day.
You as well.
Court does call the case of the People versus Copio Vitale.
I'm going to read the people. Good morning, Judge Calvert, on behalf of Mr. Vitale, who is approaching the podium and will be standing to my right.
Your name, sir?
Procopio Vitale.
What are we doing?
Good morning, Your Honor. Today is the date and time set for probable cause conference. So I was just appointed on the case. I'm still waiting on a little bit of initial discovery. We are likely going towards a resolution. Mr. Vitale is already in treatment court for his felonies. He's going there later this morning.
Adjournment?
Yes, Judge.
February 29th.
Thank you, Judge.
Or January 29th, excuse me.
Thank you. And just to confirm, he is his bond is set for release to treatment on this case as well, or is that correct or no?
I'm sure it is.
Okay.
I think I had done it at an earlier time. If it's not, you can submit an order to the court and I'll deal with that.
Okay, thank you, Judge.
29th, 2026, 9 a.m. bond continue. Court calls case People versus Javante Cadell.
People.
Mike Gaddy, Assistant Public Defender. Mr. Kilwald had to run home for a family or for a furnace emergency, actually. He asked me if I would cover this matter for him. He has submitted a green sheet. He said he was asking for an adjournment if Mr. Cadell appears.
All right, where is Mr. Cadell? We don't have him checked in.
I don't have any explanation as to his
We
work.
don't have him on Zoom.
He did tell me that he had not seen him in the courtroom, Judge.
Pardon?
Mr. Kilwell did inform me he had not seen Mr. Cadell in the courtroom.
Should have led with that. Bench warrant will issue for defendant's failure to appear.
There's a
Bond.
standard request I didn't make.
Bond will be setting him at a $10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls the case People versus Preston Walls.
Please assemble court David Burgess on behalf of Preston Walls, who's approaching.
Your name? Preston Walls. Thank you.
Your Honor, discoveries, we've received discovery, asking for an exam date.
People have their witnesses available the 27th.
Yes.
Preliminary examination in person will be set January 27th, 2026, 9 a.m. before Judge Barr.
Your Honor, could I maybe briefly address the issue of bond?
Briefly.
Thank you, Your Honor. Your Honor, bond's currently set at 100,000 cash surety. My client has no prior convictions, does reside with his aunt, is employed full-time as a security guard. Understand the serious nature of the charges, Judge, asking the court to at least consider a 10% provision on the current bond.
Your Honor, we object defendant's use of breaking into a car, stealing a firearm, and during the whole incident, I understand you spoke to the victim and yourself were shot as a result of the gun going off.
We don't disagree with that, Your Honor, but it's not by my client's hand. So.
Yes, I don't understand
My
that.
client did not possess the weapon.
But two people got shot.
There were 3 people present, Your Honor. My client was
2 of them got shot, not your client.
My client got shot, somebody else got shot, but he never possessed the firearm. So I'm not sure the specifics of that. One of the other 2.
But all of that wouldn't have occurred but for at least the alleged actions of your client.
I understand. I just thought the
Okay.
people, I was addressing the aggravating aspect of the case, Your Honor.
Motion for bond reduction is denied, bond. Court does call the case People versus Michael Compton.
Good morning, Your Honor. Michael Vincent on behalf of Michael Clapton, who's coming forward. Michael, state your name for the record. Michael Clapton.
Your name?
Michael Clapton.
Thank you.
Need a date for a prelim exam, Your Honor.
Discovery is complete.
I have all the discovery I need.
I don't know what that means. And people have their witnesses available the 27th.
Ooh, could I check 27th? I'm here unattended.
You're alone?
Yes, it's scary, believe me.
God.
Amanda's home taking care of her 4-year-old with a fever.
She give you, she sent you here alone.
I totally alone. I'm filing a grievance, by the way. With the
You're not, I don't even know why you're looking on your phone, because it's not gonna tell you anything.
yes. I've been sitting here for.
Your
an hour
schedule is
figuring
not
out my
on your phone. It
I
is in
need a
Amanda's
compliment
head.
Once in a while.
What?
I need a compliment once in a while. How about the 5th of February? Is that okay? 'Cause I'm looking at my calendar.
No, that would not be, see, this is the problem. You're just picking dates from.
No, I'm actually looking on my calendar.
Okay, so it needs to be a Tuesday.
The 3rd of February.
Are you?
May I approach the bench and I will.
No, I don't want to see it, because I'm just saying, I know you've got a calendar in there. All phones do.
And I've.
That's just not the one that you use. Well, you may. It's okay, I'll give you the 3rd. And then just let Amanda know if it needs to be moved to the prosecutor's
As soon
office.
as I get back.
February 3rd, 2026, 9 a.m. before who?
Perry.
Judge Perry. Bond will continue.
Thank you for the encouragement.
Okay, well, I'm just real. All right, thank you. Court calls the case, People versus Kurt Rushline. Send, no. Send them, yeah, send Amanda an email.
Good morning, Your Honor. Jay Grant Miller, P58658 on behalf of Mr. Bushline. Please state your name.
Kurt James Bushline.
Thank you, sir.
Your Honor, we're asking for an adjournment in this matter. It's our understanding we're trying to get a matter with Gratiot County resolved, hopefully via Zoom. So then we have a negotiated arrangement, I believe, with the people. We just need Gratiot to act first. So we're seeking 4 weeks. So hopefully they can accommodate getting him arranged.
Probable cause conference will be adjourned without objection, February 12th, 2026, 9 a.m. Bond continue.
Your Honor, if I could address the bond.
Yes.
Gratiot's indicating that they're not going to count his time if he doesn't have any kind of bond, so we're requesting a nominal bond. I believe he has a PR currently, so we're just requesting a nominal bond.
Objection. Bond will be set at $1,000, 10%.
Thank you, Your Honor.
Thank you. I need to leave, Court does call the cases of the People versus Jesse Ivy.
Alex Jabaloski, People.
And good morning, Your Honor. Happy New Year. Assistant Public Defender Tanazi Carey, I can really, on behalf of Mr. Jesse Ivy.
Back from the homeland.
I made it.
Welcome back and Happy New Year.
Thank you.
All right. And where is he? There he is. I got him at Oakland. All right. Sir, once you're unmuted, if you could state your name, please.
Jesse Ivy.
Thank you.
So, Your Honor, the court should be in receipt of a green sheet.
Didn't sound too confident. I have one. I know I don't have one.
Okay.
Just speaking in adjournment.
Yes, we are, Your Honor. I did get an offer from the people today, and I'd like to meet Mr. Ivy to relay that offer to him.
What, 2 weeks?
2 weeks is perfect, Judge.
Weeks of work? Okay. So I will adjourn this then out to the 29th. Probable cause conference, January 29th, 2026, 9 a.m. We'll continue.
Thank you, Your Honor.
Thank you. That's called the case of the People versus Mary Barney.
Morning, Your Honor. Katie was mercy.
Michael
Oh,
Gaddy, Assistant Public Defender on
Hello.
behalf of Ms. Barney, Your Honor, who's approaching.
Mary Barney.
All right, what are we doing in this case?
Your Honor, I've had a chance to speak with Mr. Hawthorne in this matter. I have not had a chance to speak with Mr. Dowd about the companion matter. I'd ask the court to, there is an offer from the people. I'd ask the court to adjourn this matter 1 week. I think I'll be able to speak with Mr. Dowd and we'll be able to move this case along at that time.
Both cases?
Yes, Judge. I'd ask the people to keep the offer on the arson matter open.
Probable cause conference will be adjourned January 22nd, 2026. Excuse me. Yes, you may. Should, and I'm just going to put it this way, and it may not. Or may have to be withdrawn, but that's because of additional information that may be forthcoming.
That is, yes, Your Honor, that's my understanding. The offer has, I guess, technically maybe been withdrawn. or sought to be withdrawn, and it'll be reevaluated based on discovery that is expected today.
Yes.
Um,
And so what I'm gonna do, and you can, and Ms. Barney, you can talk to your counsel about that a little bit more, but I understand why that's happening. And I'll adjourn it out just 1 week. Hopefully that will come in, he can get to you, you guys can discuss it, you can figure out exactly where you are. All right, fair enough?
Thank
Bond
you.
will continue. Thank you. Court does call the case, People versus Christopher Decker.
Morning, Your Honor. Jay Grant Miller, on behalf of Mr. Decker, he had stepped down the hall to go to the bathroom. If you could pass it for just a few moments.
Court does call the case, People versus, have I in custody yet? Court calls the case of the People versus Brandon Dempsey.
Good morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Dempsey, who approaches.
Brandon
Your name,
Dempsey. Brandon Dempsey.
Your Honor, I actually been talking with my client. I'm going through all the discovery. I believe we have everything. So if we, instead of an adjournment, if we could just set for an exam 4 weeks out, I think that would be sufficient. 4 weeks.
Why?
We need to go through all of the videos, Your Honor, still. I just got a couple of the videos for the advocacy.
So why
center.
would I set it for exam when looking at the videos may change your whole approach to the case?
I believe we have to hold the exam, Your Honor, now that I have all the videos. This is not going to be a wait.
Okay, then why can't it be done in 12 days?
There are some difficulties in meeting with my client to review the videos because of some of the constrictions placed on his bond conditions, Your Honor. And even when
Like
discussing
what?
previously, when I reviewed.
What is the restriction? What is the bond restriction that's causing the delay?
Previously, I had asked about meeting at the U of M Public Library, but when I went there ahead of time, I noticed there were a bunch of children there present as well. So we're just meeting at a location in Washtenaw County to review the videos as proving some difficulty, Your Honor.
Well, here's what I'm gonna do. I'm gonna set it in 12 days. Exam, we're gonna do it then. Discovery is complete. Witness, the people would have their witnesses available the 27th. Preliminary examination in person, January 27th, 2026, 9 AM before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court calls the case, People versus Austin Bryan.
Alex Jablowski for the People.
Morning, Your Honor. Kevin Hager, hearing on behalf of Mr. Austin Bryan.
Well, did they have somebody? Who did they have? Oh, are they still there?
Yes, right there was the next one.
Which one? Who do you have? Brian, okay. That was my fault because I had to. It's a good way to get shot. All right. State your appearance, counsel.
Kevin Nagel on behalf of Mr. Bryan.
All right, your name?
Austin Bryan.
All right, what are we doing on this case?
Your Honor, I just met with the people today. I just subbed into this case. Apparently, there might be another charge that's being added to the current charges that we have. We'd ask for an adjournment in this matter. And I plan on discussing with the people possible resolutions with this.
So when will we know?
Judge, there's a note that there's a warrant request and I'll look at it.
I don't know. He doesn't know either.
Probable cause conference will be adjourned January 29th, 2026, 9 AM.
Thank you, Judge.
Bond continued. Thank you. So I got it out now. Court calls the case, People versus James Holmes.
Morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Holmes, who approaches.
I know.
I'm doing okay.
What's up,
What's your name?
James Holmes.
Was it cold up here? Is that why you had to put on your coat?
Oh, yeah, man.
Oh, okay. All right, I'm just checking. All right, what are we doing?
Your Honor, we're requesting a 2-week adjournment. I got the discovery yesterday, so I need to meet with Mr. Holmes, go through it and see where we're gonna go.
Probable cause conference, February 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls the case People versus John Brown.
Andrew Childers appearing on behalf of the people, Your Honor.
And Assistant Public Defender Natalie Tate, with and on behalf of Mr. John Brown, who stands to my right. What's your name for the record, sir?
John Brown, how you doing, Your Honor?
I'm doing very well, Mr. Brown. The court has before it a plea form. That's what we're doing today.
That is correct, Your Honor.
He's going to plead guilty to an added count 2 of use of a controlled substance, that being fentanyl, a misdemeanor punishable by up to 1 year. Upon successful plea to that charge, count 1 would be dismissed. And the sentencing judge waiver box isn't checked, but
Oh, I'm sorry, Your Honor. That
Did you
we
explain
did
all of
go
that to
over
her?
that. Yes,
All
we
right.
did go over that, Your Honor. My mistake for not checking that box.
all right, very well. Could I have it this morning?
Raise your hand. Do you solemnly swear or affirm the testimony you're about to give you the truth, whole truth, and nothing but the truth? So you got it.
Yes, ma'am.
Lower your hand, state and spell your name.
John Brown.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
You understand that?
Yes.
All right. Still wish to plead guilty
Yes.
to that charge? How do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
All right. You signed an advice of rights form or went over one with your counsel?
Yes.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of it.
Yes, Your Honor.
Are you on probation or parole?
I am on probation.
Were you on probation at the time of this offense?
No. Yes, I was.
You were? Okay, I do have to advise you then that your guilty plea in this case could be considered a violation of your probation. You understand?
Yes, I've spoken with my probation officer. She knows what's going on.
All right. I have to advise you that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, sir.
All right. And understanding that, you still wish to plead guilty to this charge?
Yes, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes,
And because you believe that you are indeed guilty of this offense?
I am guilty.
January 24th, 2025, at the location of 49230 Michigan Avenue in Ypsilanti Township, Washington County, State of Michigan. Did you have fentanyl in your possession?
Yes.
Had you used it?
It was in pill form. I didn't at the time. I didn't know it was fentanyl, but yes, I did take one. Yes.
So you didn't know you had fentanyl in your possession?
It was in a Percocet form. I thought I had bought a Percocet pill.
So you didn't know what you were using was fentanyl?
Ignorant. Nope, didn't know.
But you knew, okay, but it was a Percocet you thought you were taking?
Yes, I knew it was illegal that I didn't have a prescription
You
for
did
it.
not have a prescription for it. And so you were in possession of a controlled substance that you shouldn't have been in possession of,
Yes,
correct?
sir.
All right, then there's a number of ways I can do it. Higher.
Yes, Your Honor, I would ask
Take.
that take plea to the higher the
All right,
charge.
sir, if I accept your plea, I need to apprise you that if you commit misconduct as defined under Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
I understand, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court?
People are satisfied, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14B probation. Sentencing will be February 12th, 2026, 10 a.m. before Judge Washington.
Your Honor, may I address bond when appropriate?
I don't know if it's appropriate or not, but go ahead.
Thank you, Your Honor. It is my understanding, I was not the attorney at the last probable cause conference, but it is my understanding that Mr. Brown was remanded at the last hearing for a community corrections bond violation. It's my understanding he's been in jail a week on that violation, and the basis of it was 2 missed tests, as well as I believe a test that was positive for THC. I have spoken about this to my client. He of course admits to the bond violation. He did appear last week in court knowing that he was likely to be remanded on the bond violation. I do not believe him to be a flight risk. He does have a residence where he lives with his girlfriend and 4 children, ages 16, 14, 3, and 11 months in Taylor, Michigan. He further has full-time work doing cement and flooring. He's a finisher. He is asking if the court would consider reinstating his personal recognizance bond. He is willing to do anything that the court obviously orders. He understands he cannot have a single more missed test. To my understanding, his positive test didn't have anything else positive besides the THC. He's willing to go on tether. My client even told me he'd be willing to do house arrest. I advised him that is likely not the appropriate sanction the court would issue. However, he understands he's not to do substances. He needs to.
I'm not going to change his bond. What he's going to need to do is he's going to need to talk to the probation department there. And then in Judge Washington's good wisdom, decide to change his bond.
Understood, Your Honor.
Your Honor, first I understand you say you're not going to change my bond. I just want to apologize to the court.
You're still going to ask? No.
Yeah, I just want to apologize to the court for my ignorance and not knowing that I was supposed to go over there. But I really need to get back to work. Like I'm down. I'm willing to go on tether, whatever. I just want to be able to get back to work. Right now, my girl's not working. I got 4 kids at home. Very, very high rent.
Okay, sir. What I've indicated, and your counsel knows how to get through to 14B. They can contact 14B, get you interviewed, and then get to Judge Washington to reset your bond. But at this point, I'm not changing your bond. Thank you.
Thank you, Your Honor.
Court calls case People versus Jaleesa Robinson.
Your Honor, Raymond Cook, the people.
Bring Your Honor, J. Grant Miller, P58658. Ms. Robinson should be appearing via Zoom.
You have her. Lisa Robinson. So we don't have her checked in, is that? Bench warrant will issue bond 10,000 cash surety. The warrant will issue immediately.
Thank you, Your Honor.
Court does call the case People versus Edna Grima. Grima.
People.
Washington, and we have Mr. Harris in the prosecutor's office. We're here today for a pretrial. It's my understanding that Mr. Asher is going to enter a plea of guilty to 1 count of theft. That's a 5th-degree felony. Is that accurately stated?
Yes, sir. Yes, sir.
Mr. Asher, how old are you?
28.
How far did you go in school?
Complete high school.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
Yes, sir.
Are you taking any medications?
Yes, sir.
Are you a United States citizen?
Yes, sir.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today. I'm going to set this for sentencing. It's going to take place in about 6 to 8 weeks. We're going to do a level 2 pre-sentence investigation, and we're going to come back for sentencing.
Told your attorney, this is the kind of case where I'm going to put you into my community control program. That's the plan, but you better come back here at the sentencing with a zero balance. And if you don't, plan on going to jail that day. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will? I have a document entitled Change of Plea and Entry. On the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Washington before you signed it?
Yes, sir.
Are you satisfied with the representation you've received in the case?
Yes, sir.
An enter plea of guilty to one count of theft. It's 5th-degree felony. It's punishable by up to 12 months in prison, $2,500 fine. There's no mandatory prison in the case. There's a presumption that I would not send you to prison. If you violate the terms of your community control and I do send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. The rights really haven't changed that much since we went over them back in 2020. Still have the right to make the state of Ohio prove that you're guilty of this unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at that trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, has the state been in contact with the victim in the case?
Yes, Your Honor.
What are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about August 26th of 2025, Turtle Creek Township, Warren County, Ohio, Austin Asher took property from a local business without authorization, this being McCarty's Landscaping. This property exceeded $1,000.
Anything on those facts, Mr. Washington?
Nothing on the facts, sir.
Mr. Asher, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the rights you're giving up by entering plea?
Yes, sir.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. We're going to do a level 2 pre-sentence, see everybody back here in about 6 weeks. Okay? All right, that's all.
Thank you. Thank you, Judge.
Thank you, Your Honor.
Yeah, just that way I can let him know what he needs to bring back. When we come back. Let's look.
Good morning, Honor. Charlotte Stephan on behalf of Ms. Gurna.
You take your hands out of your pockets. Whoa, I wasn't arresting you yet. Your name?
Edna Germa.
All right.
Your Honor, we're asking for an adjournment of the probable cause conference. I was just appointed and I'm still obtaining discovery.
All right. February 5th, will that work for
Your Honor, I am out of town that day.
you? I can do the 29th if you think you can get everything by then, or I can do the 12th. Which you two prefer?
I would prefer the 29th, please, Your Honor.
29th.
Of what? January, so 2 weeks.
January 29th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you.
Court does call the case for the people versus Bradley Potter.
Good morning, Your Honor. James Fefelsky on behalf of Mr. Potter on case ending in 5728.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Potter in case, actually my case is ending in 5728. Mr. Fefelsky's ends in 1624. And Mr. Potter, can you please state your name for the record?
Bradley Earl Potter.
Thank you.
It's okay.
What are we doing?
Your Honor, we're asking for an adjournment. I am still in need of discovery. And I don't think we need much time, but that's the reason.
Discovery is complete on my case, Your Honor, but in an effort to track these cases, I would echo Mr. Fefelsky's request and then also request to address bond briefly.
Probable cause conference will be adjourned to January 29th, 2026, 9 a.m. Yes,
Thank you, Your Honor. Esteban, Your Honor, my client was picked up on this matter while he was in the hospital trying to receive treatment. They ran his name. They arrested him from there. Your Honor, these cases are relatively old. One's from 2020, one's from 2021. My client has been able to stay out of trouble in that time.
understanding the charges and the seriousness of them. My client does have a place that he can stay. He can stay right in Ann Arbor. He's willing to do GPS tether home confinement. He is disabled, Your Honor. He was also accepted into the home and no vision. He did access. He was accepted, as I stated. I understand that the court would rather go the order for inpatient treatment route, and I'm happy to do that, and I can get that in today if the court's unwilling to let him out otherwise.
Response from the people.
I would object to anything. On my understanding is that, insurance was covered to appeal back to 2021. I understand the age of the cases. But I also just briefly flipping through defendant's criminal history, see a multitude of RL convictions and 2 prior domestic violence, 3rd offense convictions, which causes him significant concern for the safety of the community and for the safety of the victim. Not to mention failure to appear that for 5 years.
Motion for bond reductions denied. Bond will continue.
Would the court allow inpatient treatment?
If there's no objection to that, I customarily sign inpatient treatment.
Thank you.
So it's sent over, I'll sign off on it.
Thank you very much.
Court calls the case of the people versus Amber Almany.
Al Chepelowski for the people.
Assistant Public Defender, Nazi Carrier, really on behalf of Ms. Amber Albany, who's approaching. Ms. Albany, say your name for the record.
Amber Almany.
Judge, we're asking for an adjournment. I know the last time we were here, we adjourned this matter to allow Ms. Albany to take a gun safety course. He has completed that. We sent that to the people, so we just need to draft up the paperwork.
Oh, you
For
just
our
need
plea.
to draft it.
Yes, Judge.
Okay. You want to get it next week or you want the 29th?
I think next week is fine.
I'm okay with that as well.
Next week, please, Judge.
I'm busy. You haven't been here, so Miss Akin, I will do that just for you.
Oh, Judge, thank you.
You're gonna have to pay a price for it at some point, but not for this case. All right, thank you.
Thank
Fine,
you, Judge.
continue.
Next week. Okay.
22nd. Court calls the case, People versus Michelle Campbell.
Your Honor, reading.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Campbell. Ms. Campbell, state your name for the record, please.
Michelle Campbell.
All right. I have a plea form. Is that what we're doing?
Yes, Your Honor.
She's gonna plead no contest to 2 charges of resisting and obstructing. That's what it looks like to me, correct? Counts 3 and 4. Attempted resisting and obstructing the 1-year offenses.
That is correct.
Upon her successfully to that charge, count 1 and 2 would be dismissed. May I have her sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give be the whole truth and nothing but the truth that we got?
Yes,
Lower your hand, say your name, and then spell it out.
Michelle Campbell, Michelle Chamble, Campbell, CAMPBLL.
All right. Ma'am, it's this court's understanding that you are going to be pleading no contest to 2 charges
Yes,
of attempted resisting and obstructing. Is that your understanding?
yes,
All right. Those are misdemeanors punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
yes,
Do you understand what a no contest plea is?
yes,
All right. 2 things about a no contest plea I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these charges. You understand that?
yes,
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I do.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before a judge. Before Judge Balbo. Not sure how that's working over there, but I'll set it before Balbo because that's what we have. in the 15th District Court. You understand that?
I do.
All right. So wish to plead no contest
Yes, I do.
to the charge of attempted resisting and obstructing as contained in count 3. How do you plead?
No contest.
To that same charge as contained in count 4. How do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
No contest. No.
He said, do you understand that you won't have
Oh.
a trial?
Yes.
Okay.
I'm sorry.
No, it's okay. You had signed or went through an advice of rights form with your attorney.
Yes.
You have any question regarding any of those rights?
No, I don't.
All right. Need you to look at paragraph 5. You'll see it on the podium there. This time you have your glasses.
Yeah.
right? Okay, I remember last time.
I finally got up there yesterday.
Okay. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights that are contained on that form.
Yes.
Okay. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
All right. Court has been provided and has reviewed Ann Arbor Police Department report for their case number 25-33154. Any objection from counsel to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine defendant's guilt of these offenses. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor. Satisfied, Your Honor.
Court will accept the defendant's plea of no contest to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be February 3rd, 2026, 9 a.m. before Judge Falvo. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Ashana Barrett.
Hey, you're turn.
Public Defender Natalie Payne on behalf of Ms. Barrett, who should be present on Zoom.
Faber. Barrett,
Yes,
state your name, please.
Ashana Barrett.
All right.
Thank you, Your Honor. I'm respectfully requesting an adjournment to review the video discovery in this case.
Probable cause conference will be adjourned to February 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Ms. Barrett. We'll be in touch.
All right.
Court does call the case of the People versus Gary Carmichael. Miss Perroni, what are you doing?
I was doing that slyly.
No. Somebody help her, please.
We're having charging fights over here, so we were hoping for another flood.
And Davy, hold it. He's sitting there between you two and he didn't move?
I was trying to be inconspicuous. I was trying to participate in inconspicuity, Your Honor.
Sorry for this property, Your Honor.
No, it was not. Miss Verity, I just wanted to make sure you were gonna get back up. I thought that's all I was. That's all right. All right.
Assistant Public Defender, Chinazi K. I can move Your Honor on behalf of Mr. Gary Carmichael. Mr. Carmichael, state your name for the record, please.
Gary Carmichael. Thank you.
Judge, we're asking for an adjournment. We were waiting on media discovery. I think that we do have that now, so we just need to review it with our client.
Probable cause conference, January 29, 2026, 9 AM. Continue. Okay, thank you, sir. Court calls the case of the people versus Stefan Bruce.
Raymond Cook for the people.
Good morning, Chief Public Defender Lauren Perry on behalf of Mr. Bruce.
You have him. Pardon?
Hey, I'm here.
Your Honor, there's some additional media discovery we're waiting on, so I'm asking for an adjournment.
Will be adjourned to February 5th, 2026, 9 AM. Bond continue.
Thank you.
Court calls the case of the people versus Caitlin Quinn.
Andrew Childers appearing on behalf of the people, Your Honor.
And good morning, Your Honor. For the record, Brian Stacy, P33014, on behalf of Ms. Quinn. Morning, Judge.
Your name?
Caitlin Quinn,
Oh.
Your Honor.
Judge, at this time, I have filed an appearance, substitution of attorneys, and an order for substitution, and a request for adjournment today because I was retained yesterday to get discovery from the defender's office.
All right. Without objection, probable cause conference will January 29th work for you, sir?
Yes, it does, Judge.
January 29th, 2026, 9 AM. Bond continue.
Well, Judge, wait, may I address that? Because she's still,
No.
the bond on the ROA says personal, and she's still in jail.
Hang on. Check.
I was confused why she would be there.
Yeah, Emily's looking right.
I have it personal on the page. Yours shows what?
Right, yes. Which we have no objections to other than letting her go.
Is this her only case?
Yes, Judge. She has no priors.
Does she have a bond? But it doesn't say she's here on the bond, right?
While on bond, she's been testing. Her last test Thursday was negative. First test came back positive, and she said that's
She did have a violation
that she
from January 7th.
that she is that the one you appealed, the January 7th one? And I think that, and she appealed it, and I don't know if they got the appeal results. And she
Okay,
planned
so
on
here's
testing.
what I have.
Okay.
And the reason why she's in, her bond must have been changed. Did I issue a warrant on this? Or is she being held on that? Being held pending. Have you seen the bond violation?
I know that she tested positive, Judge.
Oh, she did.
Yeah, that's what they say, and then she appealed that. And those results are not back. And she tested negative last week when she was arrested on Thursday, and that was negative.
When did she? So on December 30th, you're saying there's a test after that one?
She indicates to me when you were incarcerated on the 8th,
When I got into jail.
which she was taken into jail on the 8th. Were you out on bond before that?
Just recently, last Thursday, when I tested and got into jail.
Right, that's when you tested.
Yes,
And
that's when I tested negative.
Is that the only time? Oh, that one was negative.
Yes.
Which one was negative?
She says when she went in on January 8th to the jail that one came back negative. But then there was one, why would there be one prior to that? Were you already on bond?
Yeah, she was already on bond. She
Okay.
was supposed to be testing, and just so council's aware, on December 23rd, she tested for numerous things. Well, she was positive for THC, which I don't think she has a card for.
She indicates she does have a card, Judge.
Okay, she didn't present it to them, but there were other things.
Not the card.
But I don't think she has a card for cocaine.
No, Judge.
Okay.
She is
Doesn't
on,
have a card for cocaine, and if that's not bad enough, that was on the 23rd, on the 30th. And you know, I'm getting older, so I don't know. Did they have a fentanyl card? Because that's what showed up on that date.
That's why I can test it.
That's the one that she contested.
Yeah, that's the one she's contested.
Yes.
So not the cocaine?
No, Your Honor, but she indicates she didn't use after on bond, she used immediately before bond. And I believe that was 6 days later.
She used the cocaine before she was placed on bond.
That's what she indicates to me, Judge.
Is it?
Yes, sir.
So when was December 17th, and it's showing up on the 23rd. Some good stuff.
What? Okay.
Yeah, and right, I revoked her bond last time she was here
Okay,
because of those tests.
very good.
I am not inclined to change it at this point. It's gonna sit where it is.
Well, Judge, if I
If
may,
somebody needs, well, it's gonna sit where it is until I get the results on the fentanyl. If she's contesting this, there's fentanyl in her system.
okay.
What about my last test from when I got?
Yeah, what about the jail test on the 8th?
What?
What about her negative jail test?
I don't know. I don't have a report on the jail test.
Oh,
And I don't know what kind of test that was. I mean,
the
I don't
urine
know.
test?
Yeah.
Urine. So I'm assuming it was a drug panel.
It was like.
Right, but I don't know if it went over through our system at community corrections. I don't have a report on it.
Right.
So I don't know if it was clean or whether it was or not.
But she would continue to test, Judge, and I believe she would continue to test
She
negative.
had 3 tests. And 2 of those tests, I mean, absent her prescription medications, 2 of those tests were dirty for something. I'm not changing my decision. I will take a look at it again if I get that other test.
Okay,
Or whatever, if I get the other test that she says she took, if it meets with the certain standards, or if, yeah, I'll look at it. Or if the results of the challenge to the fentanyl comes back, then I'll take a look at that certainly also.
we'll address that on the 29th then, Judge.
Yep.
Well, thank you for your time.
Thank you.
Oh, my.
Courthouse case, People versus Jason Campbell.
Good morning, Your Honor. Assistant Public Defender Dodgy Leva on behalf of Mr. Campbell.
Where is he?
Your Honor, I believe he's appearing from Sacred Heart.
From where?
From treatment, I believe Sacred Heart.
Okay. Mr. Campbell, can you state your name?
Jason.
I have before me a plea form that indicates that he's pleading guilty to the charge of receipt and concealment of stolen property, 200 to 1,000. The 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of his agreement.
And that is correct, Your Honor.
All right, Mr. Campbell, can you raise your right hand, please, sir?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
I don't know if we're gonna be able to make it through this. His Wi-Fi is bad. State your name again for the record, please, sir.
Well, Your Honor, I think we may need to adjourn this. Or
Yeah, I'm gonna have to adjourn it because there's no way we're gonna make it through the plea with his Wi-Fi. Sir, I'm gonna adjourn your matter over a couple weeks. And we're gonna have to have a better Wi-Fi connection in order to take the plea. Okay? Sir, you're breaking up. You understand what I just said?
Yes, Your Honor.
Okay, thank you. I'll adjourn this over to January 29th, 2026, 9 AM. Bond continued.
Thank you, Your Honor.
Hold the form in. Court calls the case People versus Tenaris Williams.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Williams, Judge.
Your name?
Tenaris Williams.
Thank you. You're requesting an adjournment.
Yes, Your Honor, there's still some discovery outstanding.
Probable cause conference will be adjourned January 29th, 2026, 9 AM. Bond continued. All right, thank you, sir. Court calls the case People versus Sergio Castro Contreras.
Good morning again. Assistant Public Defender Don P. Leva on behalf of Mr. Castro Contreras, who appeared to advise Zoom. Mr. Castro Contreras, could you please state your name, sir?
Yeah, I am Sergio Castro.
You're requesting an adjournment.
I am, Your Honor.
Probable cause conference will be adjourned February 5th, 2026, 9 AM. Bond continued.
Thank you.
Does call the case of the People versus Terrence Ginyard.
Ready to go for the people?
Your Honor, Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard.
For the record, Your Honor, my name is Terrence Ginyard.
And Your Honor,
He's waving.
he is waiving. I do have an offer to place on the record as it stands. That offer is that he waived for the purposes of pleading to one count of the firearms possession by a prohibited person. Count 2 and count 3 would be dismissed. It would also be a plea to count 4, the misdemeanor receiving and concealing 200 or more. That would come with a forfeiture of the weapon, restitution, if any, standard conditions upon that waiver.
That's what people's understanding.
All right. Mr. Ginyard, you're waiving your right to a preliminary examination, sir?
Yes, sir, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, I do, Your Honor.
All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 3 with 4 following.
Your Honor, we would acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute to all counts, court will enter a not guilty plea. Pretrial will be set for January 27, 2025, 1:30 before Judge comes.
Your Honor,
Yes,
if we may address bond at this time.
briefly.
Your Honor, my clients, I think the court has the information from last time with regard to the blood results that he was able to take. At this time, I am still asking for his release. He's willing to do tether at whatever conditions that the court deems necessary to, he received a 7-day notice to quit, eviction notice that starts today. He has also got a kid who is autistic, whose birthday is today. He lost his job, unfortunately, as a result of this case, understandably so. He's going to need to move out of that location, as the court knows, for purposes of securing new housing for his family, his children especially. I would just ask for a plea for his release at this time on PR.
Any response from the people?
No, Your Honor.
Well, why are you drinking?
Sir?
Go ahead.
So I got the blood test on the 2nd to show that I wasn't drinking. I wasn't drinking, Your Honor, on the 22nd. I didn't have any alcohol. That's why I went on my way to pay for a blood test. And the blood test, the levels was 1.0 and it said 1.4 is 0 to low alcohol.
Yeah, but
Yes, sir.
I remember going through all of that last time, and I'm telling you that that test doesn't tell me much.
We understand that, Your Honor.
Because I've got repeated tests where on the 22nd and the 27th, you're testing positive, you're drinking.
The one time I did say that I was drinking in November, Your Honor, I did admit to that. I definitely did, and you said we'll put it for
Put it over.
we'll adjourn it or whatever. And then we just got to this adjournment with what I proved that I wasn't drinking. And you
No, you didn't.
sir.
Oh, hold on.
Okay.
You didn't. That's not what that test shows me.
I have, so CMH has given me what I wanted to tell you, a shot.
The Vivitrol?
Yes, and that's like an alcohol blocker. And they said if I drink on that, bad things can happen to me.
Where is that?
That's what CMH, sir.
Your Honor, I don't have receipt.
I don't have that before me. You're telling me that
that's what I'm going to be put on. I'm already taking.
So you're not put on it right now?
No, sir.
Your Honor, I would ask for consideration for random drops at this point, if the court would be willing to consider that. I think that would, I think testing in front of someone at this point may be helpful in terms of monitoring the situation versus the scram tether or sober link. I would ask for consideration for that. I do know that my client has a desperate need to leave the jail.
I understand that, but I also understand what he's done to get himself there, because he wasn't there to start with. And now you're asking me to change it, and I haven't been shown anything really that's convinced this court that those episodes didn't occur. And he's not on a medication that's going to stop him from drinking. For your mama.
Hey, dude, I'm on.
Seriously. So this is, I mean, nothing's changed from the last time that I denied it. And so he'll be up for Judge McNally. Maybe she'll feel differently than that. But
I'll do anything to any type of drops, though, Your Honor. They do want to put me on the thing today as far as the Vivitrol. They told me tonight I can get a shot, but it's also if I'm going to be here.
You're telling me that, but I don't have anything that indicates that. I have nothing in writing saying that's what's going to happen.
I just was trying to move, man. I know I have to move, but I have a 7-day eviction. Since I've been in here, I don't really know what to do. I don't. I have autistic son. I have a lot at home.
Again, here, I understand and I can appreciate the circumstances. That
No
you're in.
scram tether or anything I can do, sir, for you? Anything, just for a week, just to show till I come back to court?
I'm not changing my position on it. I've said what I've said. You can take it before Judge McNally. She may feel differently. All right. Bond is denied. Thank you.
Thank you, Your
Motion
Honor.
for bond reduction. Court calls the case People versus Jose Che Gannon or Gonan.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Jose Che Ganyan, who's present on Zoom. Sir, can you please unmute and state your name for the court?
Yes,
my name is Jose Shaiganon.
Thank you, Your Honor. I did submit a green sheet already. However, I did speak again to my client, so I would ask the court to disregard that. We are asking to set the case for preliminary examination. Discovery is complete to my knowledge.
People have their witnesses available to 27. Preliminary examination in person, January 27, 2026, 9 a.m. before Judge Parr. Bond will continue.
Your Honor. Thank you, sir. You're all set.
Court calls the case People versus Vershawn Vincent.
This is Public Defender Hannah Apple, appearing on behalf of
Mr. Benson, will you state your name for the record? Your Honor, the court should be in receipt of the plea information.
I have a plea form that indicates that I'm pleading no contest to 2 charges of attempted resisting and obstructing a police officer, both 1-year offenses. Upon a successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes.
May I have him sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand, state and spell your name.
Sean Benson, BERSHAUNBENSON.
All right, you're gonna have to speak up a little bit, okay?
Rashawn, BERSHAUN.
All right. Sir, it is this court's understanding that you're gonna plead no contest to 2 charges of attempted resisting and obstructing a police officer. Those are misdemeanors, punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these 2 charges. You understand that?
Correct.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Correct.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Bravo or her successor in the 15th District Court. Do you understand that?
Correct. Correct.
Okay. Still wish to plead no contest?
Yes.
To the charge of attempted resisting and obstructing a police officer, how do you plead? As contained in count 3, how do you plead?
No contest.
To that same charge as contained in count 4, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Correct.
All right. You had signed on your behalf an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
The rights, no.
No? Right down below you on the podium, copy of 1, look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights in that form.
Correct.
You understand you're giving up your right to appeal of right.
Correct.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you? You're doing this voluntarily
Yes.
and of your own free will.
Correct.
Court has been provided and has reviewed 2 police reports from the Ann Arbor Police Department. And one being their case number 2444505 and also 2444468. Any objection to the court having reviewed those reports?
No, Your Honor.
No. Sir, based upon a review of those reports, the court does find that there's sufficient basis in which the court could determine the defendant's guilt of these offenses. Sir, if between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Correct.
I'm sorry?
Yes, sir.
You understand? Okay. Counsel, are you aware of any other promises, threats, or other inducements which have led to these pleas?
No.
No, Your Honor.
And have I complied with the court?
Defense is satisfied.
Yes.
Court will accept the defendant's pleas of no contest to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 3rd, 2026, 9 a.m. For Bravo. Bond will continue.
Your Honor, may I briefly address
You
bond?
may.
Your Honor, Mr. Benson is asking the court to consider a 10% option. I know that he previously failed to appear. I believe the bond is set at $25,000 cash or surety. He's asking for that 10% option. He informs me that he is now employed. His life is in a better position than it previously was when he had failed to appear back in July. He's working at Vertical Construction, and he also at this time has accepted responsibility and has entered a plea as the court's aware, set for sentencing in the 15th, and he understands if he were to violate his bond and not appear for that, there would be repercussions that he would have to face with the court.
Okay, I get that, but here's what the problem is. Back. And I really don't know whether to trust him that he'll appear or not, because on August 28th, 2025, he didn't appear before the court. Court issued a bench warrant. We recalled that, or somehow or another, you came into custody. I think we recalled it. And set another date for you, which was in October. Now, what you were doing between then and then, I'm not, man, we set a date in October for you to come back. You don't show up.
Yes, sir. You could definitely trust me. I did talk to the attorney on that day.
On which day?
On the last court day that I missed, and I was supposed to be on Zoom, but I had a miscommunication about the time.
Hey, okay, I hear you.
I logged in late.
Pardon?
I logged in late. I did talk to her and told her I was going to accept the plea on that day. I just logged in late that day, and I wasn't let into the courtroom.
Okay, so that was in October, or in, yeah, October. So what brought you back into custody?
Your Honor, he had contact with the police, I believe, in Farmington.
Auburn. He was
Auburn.
pulled over because of window tint.
But, okay, get my point on this. I already had two, and then you don't come back in. You say you signed in late. I get that, but then you don't come back in. You have to be stopped by the police and then brought to us.
Yes.
That's a problem.
I understand that, sir, and take full responsibility.
And so in that respect, I can't say that you'll appear. Maybe after dealing with the 15th District Court probation, they can make a recommendation to the sentencing judge and they'll release you, but I'm not going to give.
Can I just ask one question regarding court rules?
Court rules?
Yeah,
sure.
Court rules. I read that, during a court proceeding error, that it was supposed to benefit the litigant.
During what?
During a court proceeding. I believe there was an error during my arraignment.
In your arraignment?
Yeah, during my arraignment, my bond was originally set at 25,000, 10%, but the judge who arraigned me changed it to 25,000 cash or surety, saying that it was a mistake made, and that was his basis.
At which arraignment?
I think he's talking about the arraignment that he just came back in on the bond or the failure to appear warrant.
That it was set at, say again?
Yeah, I was prepared to make the 10% bond, but it was changed at my arraignment to 25,000 cash assured. He said that.
No, that's not what it was changed to. That is what I ordered when you failed to appear for the second time.
Okay, I apologize, but the court entered it in the computer wrong, and it was.
I don't know what happens in terms of entering it in. All I can tell you is that when I issued the bench warrant on October 9th, it was $25,000 cash surety. And so when you came through that arraignment, when you finally showed up sometime this year or whatever you showed up, then the magistrate held that bond that I had set on your warrant. So there was no error in terms of what the people in the court did. I don't know if there was a paperwork error. I don't see it. All right, thank you.
Thank you.
I need a blue form. Did you give me one? Right here. That's just a long time. Court does call the case, People versus Zion or Cheatham, Cheatham Zion or Zion Cheatham, actually.
Assistant Public Defender Jay Bellinger on behalf of Mr. Cheatham, who should be appearing via Zoom, Your Honor.
Mr. Cheatham, state your name, please.
Zion Cheatham.
And Your Honor, I am just asking for a brief adjournment on this. I'm just asking to adjourn for mitigation purposes. We're working on that currently.
January 29, 2026, 9 AM, bond continued.
Thank you very much.
Thank you. Thank you, Mr. Cheatham.
Thank you.
Court calls case People versus Tim Shelley. Are they ready or? Okay.
Okay, well.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Shelley. Mr. Shelley, will you state your name for the record?
Tim Frank Shelley.
Your Honor, we are here today on a bond violation as well as the PCC. Mr. Shelley is asking that his case be set for preliminary examination, and he would admit to the violation. He would ask for time served on that.
The discovery is complete. Would the people have their witnesses available to 27?
Yes.
Preliminary examination in person. Set January 27, 2026, 9 AM. When did he come into custody?
I've got about 22 days.
No, but this last.
Oh,
Judge, I can check real quick. I think it was just a few days ago. On this most recent.
When he came back. On the 11th, Judge, so 4 days.
all right. Here's what I'm gonna do. On his bond violation, I'm gonna sentence him to 15 days. Washington County Jail. Well, I don't want to do it that way. I'm gonna do actually 20 days, Washington County Jail. Credit for balance to be served. And one can address an altering of that sentence at the prelim. That's on January 27, 2026, 9 AM before Judge Washington. But the intent of the court is that he stay in until the prelim.
Understood. Thank you.
Thank you. Court calls case People versus Antonio Cornelius.
Mackie on behalf, or requesting permission to practice under Michigan Court Rule 8.120 under Senior Assistant Public Defender Joy Gaines.
Well, for Miss Gaines, I'll give you.
Thank you, Your Honor. Hannah Mackie on behalf of Mr. Cornelius, who should be on Zoom.
Cornelius, state your name.
Antonio Cornelius.
Thank you.
Your Honor, we're setting this matter for preliminary exam and all discovery is complete as far as we are aware.
People have their witnesses available to 27.
Yes.
Preliminary examination in person, January 27, 2026, 9 AM. That's before Judge Barr. Bond will continue.
Thank you, Your Honor. Mr. Cornelius will be in touch.
Court calls the cases of the People versus Kirby Snyder.
Stephanie Cannon on behalf of Ms. Snyder, who's approaching.
Your name, ma'am?
Kirby Snyder.
Wow.
Excuse me.
I mean, bless you.
Thank you, Your Honor. Thank you, and I'm sorry, Miss. Did I sneeze? I'm sorry.
I just sneezed on the deputy.
He had all this protection.
Really?
Yes, Your Honor.
Go ahead.
I don't know. I'm gonna do some green sheets. I spoke to Ms. Snyder about, we were initially just gonna have her cases set for preliminary exam, but I just spoke to the prosecutor about her case. We're gonna adjourn it for 2 weeks to see if we can resolve it instead. I'll do some green sheets for the case. If not, we'll be setting them for preliminary exam.
Okay, because she still has this, she still got a bench warrant from the community corrections violation. Is that right? That's on case 1922.
It's not my case. My cases are ending in 04.
They gave me one extra file. She only has 2 cases, right?
Okay, because I thought the other case was dismissed under Miss Costantino. Is that correct?
No, that's not even her.
Okay.
I don't know why it was banded together.
It's- No, yeah, no, you're fine. Don't worry about it. So, Your Honor, we're asking for just a 2-week adjournment to see if we can resolve this short of the preliminary exam. Oh, Your Honor, you already signed an order releasing her to treatment. I don't know what's going on, but they're struggling to get people released to treatment right now. Mrs. Kirby, I did email Patrick and Sarah again to see what the whole is. So.
And just so that we're clear, I don't know if there's a struggle. I will speak up for those at the jail. There's a lot of people that are leaving for.
Yes. Mhm.
It's just.
I didn't mean it in a negative way.
Capacity,
You know I
the
didn't.
number we have has exceeded the capacity that's out there. And they are trying to get people out as best as they can. And my understanding are working very hard to try to do that, so.
Your Honor, I 1000% agree. I didn't mean to imply otherwise. That was.
Oh, no, you were trying to
Sorry.
slam them.
That was.
And I wasn't gonna let you.
Thank you, Your Honor, for fixing
I
that.
was standing up for them.
Yes, you were.
How
So-
long adjournment do you need?
2 weeks, 2 weeks, Your Honor.
2 weeks. Probable cause conference, January 29, 2026, 9 a.m. bond continuing.
Thank you so much, Your Honor.
Thank you.
We'll talk to you this afternoon. Yeah, Coach, Your Honor.
What? Why do you not have those?
Because it was supposed to be.
You want to know what? No, I don't want an answer. Watch, the next time she's not gonna have a green sheet. Court calls the case, People versus Tegan Donnell. Donald. This is one I have to address.
Let's get the book on behalf. Ms. Donnell? Ms. Donnell, could you please tell the court your name, ma'am?
Tegan Summer Donna.
What are we doing?
I'm going to be requesting an adjournment. I believe I did provide a green sheet to the court.
Yes, you did. You want to address the bond violation?
Yes, John, with regard to the bond violation, I believe Ms. Donnell would be prepared to admit to it, and she has checked herself into treatment.
I do struggle with addiction, and I am currently have checked myself into Spera Recovery Center.
To where?
Spera Recovery Center, it's detox. Excuse me, I don't mean to interrupt you. I did a level of care assessment. They recommended a 30-day program, and then I hopefully will go to
Are you
transitional housing.
I don't have any of that.
Your Honor, I did provide that to the court.
And I have spoken to my bond advisor as well.
Where's the Dawn from? Is she in currently?
Yes, Your Honor.
Was she in at the time of these?
I believe she checked herself in after the violation. Is that correct, Ms. Donnell?
I found out about my violation actually like.
Oh, which violation?
I'm sorry, what? Yes, I've been struggling a lot, if I may speak.
I have 1, 2, 3, 4, 5, 6, 7
May I adjust?
tests for cocaine.
And Ms. Donnell, my understanding is that you.
And are you on a prescription that's an amphetamine?
No.
And so 3 tests with the cocaine that also tested positive for amphetamines. Then on January 13th, she missed.
Yes, Your Honor. And she will freely admit that to the court, that this is a result of her struggle with addiction, and that she has now checked herself into Spera for detox.
No, that's not going to be good enough. You didn't do that until when?
I've been there since Saturday.
Yeah, that's the problem. these tests, and you say it's because you were struggling with these, and that you all of a sudden got a notification of a positive test. Your positive test date back to November 26th.
There was, may I speak?
Yeah.
The first test I had was positive and it was a false positive. So I sent that out and it came back negative. Then after
Which
that,
test is that?
the very first one,
On what date?
November 26th, probably. After that, I have struggled with addiction. I went to Oakdale for 3 days. I got out and I've been homeless and I didn't have a place that was substance free and I continued to struggle. I take responsibility for my substance use and I continued to struggle and if I have to go to jail, like I understand that. But I didn't know I had a bond violation like warrant out for me until after I went to Sparrow.
So after you went?
Yes. But I assumed it would happen eventually anyways. I'm just surprised it didn't happen sooner. I struggle with addiction.
I get that, man.
I know.
And I don't know why you're not an inpatient when I'm looking at this.
I am an inpatient.
For 30 days.
Correct. I'm here with an RSS, a recovery support specialist with me.
Maybe I should have put it this way. Why weren't you in there earlier?
There's no excuse. I went to Oakdale for 3 days for a little like detox thing and I got out and I was like, oh, I got a job. I'll be able to do that. And I was still struggling so much. I didn't follow through with the job. So as soon as I realized I wasn't going to be able to do the job, I got myself into inpatient. I shouldn't have expected myself to be able to work a job when I was getting high.
Where are the amphetamines coming from?
I don't know. That may be a medication I'm taking or something. Or something in this. No, I don't like, it's difficult to be up here talking about, hey, I struggle with in the first place. But
And you're saying the reason that you missed your recent test is because you're an inpatient?
correct.
It's a 30-day, and so when are you expected to be done with this?
I checked in on the 10th. So roughly about the 9th or 10th of February.
Adjourn this to February 12th, 2026 at 9 AM. That's for PCC and sentencing on the violation. I will let you continue in treatment, but you are to get over to community corrections for placement on a tether, location tracking tether.
Thank you, Your Honor.
Her bond will continue otherwise.
Thank you. Should she go over there now?
She better.
Okay. You know. Okay. Thank you.
Court calls the case, People versus John Douglas.
Andrew Childers appearing on behalf of the people.
Sorry to interrupt you. Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Douglas.
Your name?
Good morning, Your Honor. This is Sean Douglas.
You're requesting an adjournment.
Yes, Your Honor. I also have here, after Mr. Douglas gets a chance to sign it, a referral form to mental health treatment court.
Got it. I don't know what their timing on everything is. But there you go, February 5th, 2026, 9 AM.
And Your Honor, may we address bond as well?
Briefly.
Thank you. Your Honor, Mr. Douglas is in a vastly different situation than he was when he missed court previously. He now has stable housing. He has a support system, which includes his father, his roommate, and several friends, and Ozone House. He also now has a bus pass, so he has stable housing and transportation so that he could return to court. We are asking that the court consider a personal recognizance bond for him so that he can show Your Honor all the improvements and efforts that he's made.
Any response from the people?
Mayor, I leave it up to the discretion of the court.
I've got a concern that we don't have a full assessment of him, and I've got weapons charges. That's a big concern to the court.
I understand your concern. It is my understanding, Miss Akiri Akinruli has been in communication with Mr. Douglas's father, and it's my understanding the mother is the complainant, and that she is at this point asking just for him to be held responsible for the damages to the vehicle. So I'm not excusing his behavior, but I think this is a family situation and a little more complex.
Right, but until I get an assessment, given all of that, I'm not gonna change anything. He's gonna stay right where he is. See, the motion for bond reduction is denied. I'm gonna leave him there. Maybe once there is the assessment or initial assessment for mental health court, I'll have a better picture of it, but under these circumstances, I'm not doing it. All right?
I think.
Court does call the case, People versus Shalisa Floyd.
Approaching.
Why is Cannon hugging people in the aisle? Your name, ma'am?
Oh, Shalisa Floyd.
Thank you.
Your Honor, requesting to adjourn this matter. We're still waiting for some discovery.
How soon do you have it? I mean, if we're waiting discovery.
So I believe it's supposed to, we requested it the other day and I was supposed to be receiving a link, a watch guard link for the discovery, but I never received that link. So,
Give it to them as early as next week.
so 2 weeks.
Can we,
What did you want to say?
I was-
You wanted to say something?
yes, sir. I was just,
I'll talk to you. I like talking to you more than I like talking to them. So go ahead. What do you want to tell me, ma'am?
I was just gonna say 2 weeks because I'm starting a new job at Chrysler, so I don't know what my, schedule
Your
is. gonna-
schedule's gonna be?
Yes, sir.
All right. So when do you start that?
Next Thursday.
So you start that on the 22nd?
Yes.
All right. And then you're gonna have to get to your attorney, and everybody's gonna have to look at it. While we're doing all that, you don't want to lose your job.
No, sir, I don't. Thank you.
And here's what I'm gonna do. I'll put the probable cause conference out to February 12th, 2026, 9 AM. And she's working and doing that. If she can find a way to get it done, then she submit the forms, let her appear via Zoom. And we'll try to time it up so she won't lose her job. You're welcome.
Thank you.
See, if they had said it, it would have all turned in and I would have just denied everything. But the way you asked. All right,
Address bond, sir.
pardon?
Can we address bond also, sir?
Your bond?
Yes, sir.
Oh, you're
if
telling
she
her what to
asked?
say now?
If she asked, you won't deny it.
All right, what about her bond?
My bond condition.
Your Honor, she has right now, there's a no go to her current house where she lives, so she's not able to go there. So we are asking if we could change that to allow her to go back home Right now, she's been living at friends' homes and she's still paying rent and mortgage on that home that she can't go to.
Your Honor, the people that oppose the modification to the bond, they'll go to, especially as the complaining witness is currently residing at that location. He is in the process of moving out. He's asked us to get at least 2 weeks for him to be able to do so. But at this time, he would like the notice to.
Your Honor, it's her home and he has no right to be staying in that home at this time
So how do you get in there?
because there's no go.
No.
He was staying with her as, but
Yeah,
not as a resident there. It was just a one-time thing.
We were dating.
what?
We were dating. I'm in love with him. I am in love with him.
Okay, that's fine. I get that. And I guess that was gonna be my point. I understand it may be her home. But I don't really think if this court's gonna be consistent, I'm not going to change that where that person is still in the premises.
So in 2 weeks, he indicated that he's moving out within 1 to 2 weeks. Should we,
Well, here's the problem. Even if she doesn't, or he doesn't move, then she's just caught at that point. I'm not going to change it to allow him to go, or allow her to go back until he's just vacated the premises.
Your Honor, when we receive confirmation that he has left the premises, I'll reach out to defense counsel. We can submit a stip to allow her to return to the address.
Well, I've given him an eviction notice already.
Okay, that's gonna be a whole other problem. Because whenever people are in the middle of a domestic,
I didn't give.
where's the property?
it is 8359 Brookstone, Willis, Michigan.
I don't know if that comes here or not. It's in Washtenaw County.
Yes.
Yes, sir.
Right next to
Is
Ypsilanti.
that 14B? Is it 18? Well, there's only, well, if it comes before me, I'm gonna throw it out. Because they don't allow eviction cases on domestic cases either, for very good reason. So he needs to just move. And then there'll be the stipulation and you can go back.
Thank you, Your Honor.
Okay, bond will continue.
Thank you.
Court calls the case, People versus Derek Graham.
People.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Graham.
Your name?
Derek Graham.
Thank you. What are we doing?
Your Honor, at this time, Mr. Graham has indicated that he is not interested in any kind of plea agreement. He wishes to set this for preliminary examination and to have our office address bond.
And what?
And to have our office address bond.
So discovery is complete.
That is my understanding.
Do you have other witnesses available the 27th?
Yes, sir.
Preliminary examination in person, January 27th, 2026, 9 a.m. before Judge Washington. Bond will continue. Or you want to address bond? Go ahead.
Thank you, Your Honor. Your Honor, Mr. Graham is indicating that he has stable housing. He has Section 8. He is asking that the court consider that so that he can return to his housing and not and be able to maintain his voucher. He also is in the process of gaining custody of his son. He indicates that he does have a friend of the court hold.
That's what?
A friend of the court hold out of another county for his child, and that he believes he will be able to post for that as well. Post for that in
The
order
friend of
to
the
make a
court?
payment to the friend of the, for the friend of the court to a different county. And that he will be able to make that payment towards his arrearage to that court and would be able to be released if Your Honor would allow him to have a personal recognizance fund. He's also an entrepreneur. He has his own business. Thank you, Mr.
Response?
Your Honor, the people who oppose reduction in bond, the defendant in this case said harassing text messages to the victim, in which he says, "I'm about to go to jail, fuck it, I just want this shit over with. I promise one of us is about to die tonight." Those statements are of great concern to people.
Those alleged statements are from July.
From what?
From July of last year.
That makes it
Graham
better?
was on- Mr.
Go ahead.
No. What I'm going to say is that Mr. Graham was unaware of the warrant and that this was pending. However, there's no allegations that I have heard that there's been anything since that July 2025 incident. So in 6 or so months.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
Call the case, People versus Brandy Graham.
Call all of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Graham, who should be appearing via Zoom.
1 second, I can hear you. Go ahead.
I believe Ms. Graham is on Zoom, hopefully.
Is she? Yes, there she is. Ma'am, can you state your name, please?
Brandy Graham.
Thank you.
Your Honor, asking this matter be set for preliminary examination.
All discovery is complete.
Yes, Judge.
People have their witnesses available to 27.
Yes, Your Honor.
Preliminary examination in person, January 27, 2026, 9 a.m. before Judge Barr. Bond will continue. Thank you.
Thank you.
That's an in-person proceeding. Court calls case People versus Matthew Wallace.
Your Honor, Raymond Cook for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Wallace. State your name for the record, sir, please.
Matthew Wallace.
Thank you.
You're requesting an exam date, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to 27.
We'll do our best, Your Honor.
Preliminary examination in person, January 27, 2026, 9 a.m. That's before Judge Washington. Bond continued. Calls the case People versus Frank Green.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Green, who should be appearing via Zoom from the Home and New Vision, Your Honor.
Yes.
And we do have a waiver form completed on
Mr.
this.
Green, can you unmute? You need to unmute. I can't hear you. Oh, there you go.
Okay,
State your name. State your name.
very green.
All right. Mr. Green, you're waiving your right to a preliminary examination?
Finally got into treatment.
Okay, you're in treatment, but your counsel has indicated you're waiving your right to preliminary examination. Is that true?
So. That's
Mr. Green, are you going to waive your right to have a preliminary examination?
Yes, sir.
I don't think that's what's happening here.
Your Honor, we do have a really good relationship with Frank Green in our office. He's one of our favorites for what it's worth.
Yeah, no, I got you, but I don't know. Mr. Green, can you hear me?
Yes, and
Okay. Are you waiving your right to have a preliminary examination? Yes? Okay. You understand that that's a hearing where the people would have to show by probable cause that the offense alleged was committed and that you did it. You understand that that would be that hearing?
yes, sir.
Yes? Okay, you understand that you're not gonna have that hearing? You got that? Okay. People also waive their right?
Yes, Your Honor.
Yes, sir. Great thing about hand signals. Great. Preliminary examination having been waived, defendant is bound over to circuit court on the single count.
Your Honor, we acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Your pretrial will be set for March 10th, 2026, 1:30 before Judge Kunke. All right. Thank you, Mr. Green. You take care of yourself.
Thank you, Your Honor.
Court calls case People versus Alicia Wittenberg.
Andrew Childers appearing on behalf of people.
Assistant Public Defender Jay Ballinger on behalf of Ms. Wittenberg. Ms. Wittenberg, can you please state your name for the record?
Alicia Wittenberg.
Thank you.
And Your Honor, we are here for PCC today. I just received an email earlier this morning, and I haven't been able to unfortunately do anything with it, but from 14B stating that she has been accepted in the 14B recovery court.
That she has been?
Yes. So the MOU would still need to be filled out, as well as the plea form, advice of rights, et cetera. So I would need an adjournment to accomplish that. It is. I did also submit an email from Sarah Stewart to the court. I was able to speak with her yesterday with regard to the insurance situation that Ms. Wittenberg brought up last time. Unfortunately, it's just not going to happen that she is able to get into inpatient from the jail with her insurance. So I would plead with this court to allow her to be released on PR. She's been accepted into recovery court. She can come back for a plea.
There's going to be a plea, though.
Yes, Your Honor.
So how soon are we going to be able to work up the plea?
I imagine we can get that done as early as next week if the court would allow.
And what I'll do, if she's going to go, I'll adjourn it out 1 week. I'll take the plea. Once the plea's done, then certainly I'll consider release of some type of factor.
Okay, Your Honor.
All right. But I want her. I'll adjourn this then to January 22nd, 2026, 9 a.m. Bond continued.
I will have everything ready for you.
If they can get everything written up, then we can get her on her way into that and adjourns. Okay?
Okay, thank you.
Thank you. Court calls the case, People versus Zariah Griffin Bills.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Griffin Bills, who approaches.
I want to hear.
Hi, I'm Zaria Griffin.
Hold it. Say it.
Zaria Griffin Bills.
Zaria.
I'm so sorry.
No, I think I messed that up the last time.
I've been contemplating it back and forth in my head too, Your Honor.
Well, when I said it, I realized I don't think that's all right.
Your Honor, I am just asking for a brief adjournment. We did submit mitigation on this. We're just waiting to hear back about that.
I got it. Probable cause conference, February 5th, 2026, 9 a.m.
Okay.
It's going to be on a Thursday.
Okay, perfect.
All right. Bond will continue. Zaria, right?
Do you need sheets or anything?
Oh, I remember today.
Okay.
Thank you.
Thank you, Your Honor.
Court calls case, People versus Gage Hammond.
You're ready to cook for the people, right?
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Hammond, who stands to my right. Please state your name for the record, sir.
Gage Hammond. All right. I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That's correct, Your Honor.
That is correct, Your Honor.
May I have him sworn?
Solemn swear or affirm the testimony you're about to give be the truth, whole truth, and what you got. Lower your hand, state your name and spell it.
Gage Hammond, GAGEHAMMOND.
Mr. Hammond, it is this court's understanding you're going to plead guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Understood.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes, understood.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Do you understand that by pleading guilty, you'll not have a trial of any kind?
Understood.
You signed or had cause to have signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
Sir.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Yes.
Okay, were you on probation at the time of this offense?
Yes.
All right, then I do have to advise you that your entry of a plea in this case could be a violation of your probation.
Yes.
You understand that if it is considered a violation of your probation, you could be sentenced to the maximum term allowable by that other court. You understand that?
Yes.
Yes?
Yes.
Understanding that, you still wish to plead guilty in this case?
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of April 25th, 2025, at the location of East Michigan Avenue near Old Creek Drive in the city of Saline, Washtenaw County, state of Michigan, were you in possession of methamphetamine?
Yes, I was.
Had you used it?
Yes, sir.
Did you know what you were using was the methamphetamine?
Yes, sir.
Sir, if I accept your plea, and between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any evaluation or recommendation regarding sentencing, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4. Sentencing in this matter will be
At 9 AM before Judge Freshour.
February 17, 2026, 9 a.m. 9 a.m. before Judge Freshour. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls case of the people versus Kristen Rivera.
Madam Mackey, on behalf of Mr. Guevara, who is approaching. Your name.
Christian Guevara.
Your Honor, we're asking to adjourn this matter. We are negotiating something with the prosecutor at this time.
Probable cause conference will be adjourned February 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
I'll touch you.
Awesome.
Court does call the case of the people versus Summer Johnson. Who's in custody?
Morning, Your Honor. Ready to cook for the people?
Hold on a second. They're not up yet. Let me try this one. Nicholas Harding. Go back, Glenn.
System plugs under document. Yes, sir. Nicholas Harding. System plugs under document before Mr. Harding. Interim requesting adjournment. We are currently negotiating.
Probable cause conference, January 29th, 2026, 9 AM bond continue.
Thank you, Your Honor.
Ardeo. Court. Recalls case people versus the Marjons.
Or you getting on to people?
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
You're still under Cannon?
Yes.
Wow. I thought it was like a whole new semester. That's something good might happen for you. Okay, permission to practice.
Thank you, Your Honor. Can you state your name for the record?
Lamar Johnson. Thank you. What are we doing?
Your Honor, we're requesting to set 1484 for preliminary examination and an adjournment for 1487.
The cases aren't related. Really?
They are, I believe they are.
Pardon?
I believe they are related.
They are related, Your Honor, which is Arno stemming from the home invasion. They were charged as two separate cases.
Got it. That's what I was wondering. So why would I do that? Set one for preliminary examination and then adjourn the other. Ms. Glenn.
Your Honor, our client is requesting a preliminary exam because he believes that.
Back up, Cannon. Why would I set a preliminary examination basically on part of a case? I realize they're charged separately, but why wouldn't they be held together? Well, let me ask this. Wouldn't it make more sense if they were held together?
I think so. Mhm.
So I guess then where are we at with the one that you want the adjournment on that would stop us from going forth on a preliminary examination on that one? Hold it. Hang on a second.
Yes, sir.
Sir, you're good. Don't worry about it. Cannon sent you up here to do this, didn't she? And she knew. Ms. Glenn, you've been set up.
Your Honor, may I?
I think you're gonna have to.
I see this. The home invasion case, we're waiting for DNA on. I don't have the DNA back as of yet. And we do think that that is pertinent to the case.
Got it.
The RNO, and it's my opinion, is tangent to that. While they were out looking for a possible suspect, they allegedly came across him. So he's not in the house, he's not doing anything, he's just.
But is this
kinda
like
out and about.
shortly afterwards? I mean, the problem's gonna be, there's going to be some testimony, I would suspect, that relates to the one case to show that the officers were acting lawfully.
Your Honor, our client said it was 4 days after.
But even, I mean, go ahead, Mr. Cook.
Your Honor, so the RNO relates to the arrest on this, but it was a couple days later. They were searching for the suspect. If the court wants to set the RNO for exam, I think there's sufficient separate to where I could run that exam.
Without mentioning or getting into the other one.
If defense counsel is willing to, I guess we can have a conversation about possible stipulations for exam purposes as to that. For strengthening the way to make this one suit.
It was like 3 days later, Your Honor, and I think it's even different officers. I mean, I guess they could say.
Right, but then the question becomes, does it not? Why are they, I don't know what the alleged resisting is, but why are they detaining him? That then gets into these other events, right?
I know you really, no, I know you really want it said. I know you do, but what the court is saying is that they made.
I mean, I'll do it, but I'm just saying.
Father's Day after me in the first place.
Okay, okay.
You gotta tell them that.
I understand. Just hold on. Your Honor, my client really would like to have his preliminary exam held. I can go over this with him again in more detail. We've discussed this type of stuff. He wants the exam. Are you holding it? I can work with the prosecutor on certain stipulations so that certain things may not need to come out.
The problem is, this is all gonna have to be, if I set it for the 27th, all this is gonna have to be explained to, here's what I'll do.
Thank you, Your Honor.
I'll give you your preliminary examination in person. That'll be February 3rd, 2026, 9 AM. That's before me. So that we don't run into any problem with why this one is set and what the court's gonna require. Then in the other matter, you're seeking an adjournment.
Yeah.
When is the DNA expected back?
6
That
months.
I don't know.
In this man. Will be adjourned. I'll just set it for February 5th, 2026. 9 AM bond continued.
Thank you, Your Honor.
Days People versus Chalice McLaughlin.
Alex Chavalowski, the people.
Sorry.
Wow. It was not you, you just happened to be in the area.
Yeah.
No, I saw it was Mackie.
I feel like it was not me, but
You feel like it wasn't you? Okay.
someone overreacted.
McLaughlin,
Not out there.
He's in custody. Oh.
is he in custody? He is. You guys have, or you're waiting on him? Oh, here it comes.
Anna Mackey on behalf of Mr. McLaughlin, who's approaching.
Alex Chavalowski, the people. Didn't say that.
You say your name.
Your name?
Alex McLaughlin.
All right, what are we doing?
Can we approach, Your Honor? Please.
As long as you bring Miss Gaines, yes.
Thank you.
I don't trust Chavalowski.
Yes, it's
Going to adjourn the probable cause conference to February 5th, 2026, 9 AM. And hopefully it's to this matter, there'll be some type of resolution. All right, thank you.
Thank you.
Court calls the case, People versus Jesus Hernandez Palestino.
Deputy, you're on agreement with the people.
Assistant Public Defender Chinasi Carey, I can really on behalf of Mr. Jesus.
What'd you do to Perry?
You said judge.
Huh? What happened to Parenty? What'd you do to her?
Nothing, Judge. She had to step out.
All right.
Thank you. Judge, I do have a green sheet prepared by Ms. Kearney. We're asking for an adjournment to allow us.
Client?
Oh. That is very important, Judge. I think I just assumed that they were on Zoom. Yes, that's what I thought.
Negatory ghostwriter.
Judge, I do not have a client. She set me up.
Oh, it's her fault?
Judge, I do not believe that this client is here. I'd asked for an adjournment.
Mm-hmm.
Yeah.
Bench warrant, 10,000 cash surety.
Thank you, Your Honor.
Well, court does call the case, people versus Deshaun Jones. Who do? Oh, okay. Go ahead. Let's try to get this one out.
Morning, Your Honor. Mike Getty, Assistant Public Defender on behalf of Mr. Jones, who's here to my right. State your name, Mr. Jones.
Deshaun Jones. Thank you.
Your Honor, this is a time and date for probable cause conference. I did submit a green sheet, but since then there's been a change of plans. We're asking for an exam. I tried to withdraw it, but apparently they only flow one way.
We don't let that happen. Discovery's incomplete.
Yes, as far as my knowledge, Judge.
All right. People would have their witnesses available the 27th.
Yes, sir.
Preliminary examination in person, January 27th, 2026, 9 a.m. That's before Judge Barr. Bond will continue. Thank you. Court calls the case of the people versus Bill Williams.
Calling for the people.
That's your last in custody.
Yeah, that's It's Apple.
Yep, Assistant Public Defender, Tepe. I can really, on the. Mr. Williams, say your name for the record, please.
Bill Williams. Thank you.
Judge, I am standing in for Ms. Apple in this matter. We're respectfully requesting that this matter be set for preliminary exam. And all discovery is complete to our knowledge.
People have their witnesses available the 27th.
Yes.
Preliminary examination in person, January 27th, 2026, 9 a.m. That's before Judge Washington.
Thank you, Judge.
Thank you. Bond continued.
27.
That was on both cases. Correct.
Yes, Your Honor, please.
Court does call the case, people versus Gregory Lee Jones.
Assistant Public Defender, Tepe. I can really, on behalf of Mr. Gregory Jones, stand for myself, Judge. Mr. Jones should be on Zoom, Your Honor.
Mr. Jones, can you state your name?
Gregory Jones.
Thank you, sir.
Judge, you're asking for an adjournment. We want to get some mitigation information over to the people.
To who?
To the people.
Who are also here for themselves.
All right. Will the 5th be enough time for you to do that?
I think that should be fine, Judge.
All right. Probable cause conference adjourned February 5th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Court calls the case, people versus Christopher Kniper.
Calling for the people.
Assistant Public Defender Jay Ballinger on behalf of Mr. Nieper, who appears to Zoom, Your Honor.
Christopher Nieper, Your Honor.
And Your Honor, you will have a green sheet before you, which I am asking you to tear up and throw away. I was in the throes of negotiations this morning with Ms. Enda, and for that purpose, we do have a waiver form in front of you today.
Yes, I do.
And I will have Ms. Zinda place it on the record on this.
The offer was for him to waive up to an RNO and DB4A, and for that RNO, there would be a delayed sentence that if he's successful with probation, it would be reduced to.
In the DV would be
That's a 4A.
7694A.
Got it. Okay. Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following.
Your Honor, we acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute to all 3 charges. Court will enter a not guilty plea. Pretrial will be set for
1:30 before Judge Cookie.
March 10th, 2026. 1:30, Judge Conkey.
Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you. Thank you, sir.
Have a good lunch.
Bond will continue.
Your Honor, may I approach the sign your signature?
Yes. Court calls the case People versus Sharice Martin.
Assistant Public Defender Tanaka Carey, really on behalf of Ms. Sharice Martin, who is approaching. Ms. Martin, state your name for the record.
Sharice Martin.
And Your Honor, we're asking for an adjournment for media. I think this court should have the green sheet.
How much time are we gonna need to get all that?
2 weeks, Your Honor.
Probable cause conference, January 29, 2026. 9 AM, bond continue.
Thank you, Judge.
Well, let me make sure. Are you going to have it in 2 weeks or?
I believe we have it now, so.
You have it now? Okay, so to get over. Okay, we'll leave the 29th. Thank you.
You.
Court calls the case People versus Javon Mills.
And Assistant Public Defender Tanaka Carey, I can really on behalf of Javon Mills
Javon Mills.
on Zoom.
Here. I knew he was here.
That's right.
Thank you, sir.
The court should have a green sheet, Your Honor. We're adjourning for mitigation in this matter.
Probable cause conference will be adjourned February 5th, 2026, 9 AM, bond continue.
Thank you.
Thank you.
Thank you. Thank you, Ms. Mill. Court calls case People versus Delonte Napier.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Assistant Public Defender Dr. Leba on behalf of Mr. Napier. Mr. Napier, could you please tell the court your name, sir?
Thank you.
And Your Honor, we'd like to please set this matter for preliminary examination. Discovery is complete.
People have their witnesses available the 27th. Preliminary examination in person, January 27th, 2026. 9 AM, that's before Judge Barr. Bond will continue. Thank you,
Thanks, Your
sir.
Honor.
Court calls the case of the People versus David Olson.
Andrew Childers appearing on behalf of the people.
Public Defender Dr. Leba for Mr. Olson, who I believe appears via Zoom. Mr. Olson, could you please state your name, sir?
Gotta unmute. David Olson,
Yes,
state your name, sir.
David Olson.
And Your Honor, I have
Yeah.
provided a green sheet to the court and requesting a German order to review the discovery as well as discuss this case further with Mr. Olson.
What's the discovery issue?
I just need to review it, Your Honor.
Pardon?
I just need to review it and discuss it with Mr. Olson.
Probable cause conference, January 29th, 2026, 9 AM, bond continue. Court calls case of the People versus Lucinda Printup.
Good afternoon, Your Honor.
Assistant Public Defender, Traffic Area, on behalf of Ms. Lucinda approaching.
Lucinda Prina.
Thank you.
Judge, we're asking for an adjournment in this matter. We have a referral. I think the court has already signed it, right?
Would it have been given to me before today?
Previously, Judge, we just need to have her set up the appointment. I think that might have been at the last.
Yeah, I thought we had, but I don't. I'll be honest with you, I'm not seeing the referral.
I can send over a new one just.
Yeah, I think you're gonna have to.
Okay.
I don't see one. What I will do then, if you're gonna send that over. Again, I don't know how fast they're going with all the changes over there. Let me just adjourn this out to February 12th,
Okay.
2026 at 9 a.m.
Thank you,
Okay.
Jana. Okay, you need a paper?
Court calls the cases of the people versus Terry Probst.
Good afternoon, Your Honor, Raymond Cook, the people.
Oh, yes.
And Assistant Public Defender Natalie Pate with on behalf of Mr. Probst. To my right, please state your name for the record, sir.
Terry Probst.
Thank you, Your Honor. Your Honor should be received a green sheet. I'm respectfully requesting an adjournment. I was just able to make contact with
Council approach. You had the bond violation?
I do, Your Honor, and I'm also prepared to address.
Okay, you ready to address it? Okay, go ahead.
So Your Honor, as I was going to say, I just made contact with Mr. Probst this morning. He provided me a new phone number. I was able to review the bond violation with him. When he was reviewing it with me, he told me that he went to community corrections on December 29th. I did then email Ms. Dozier at Community Corrections, and she stated to me that this morning that she just had the front desk check in the sign-in sheet, and it appears that he did sign in that day. If
The
he
29th?
Yes, however, it was not his day, and he would have been turned away unless we received an order from the court. Obviously, since then, Mr. Probst has had a lot of missed tests and did not go back to report. I asked him why, and he said that when he went on the 29th and they told him he wasn't on the list, he was confused, did not come back. I advised him that that was the wrong thing to do, and he should have continued contact with them and gone back to community corrections. He did also, Mr. Probst, that is, provided me with a document from Home of New Vision that he says is from 2 days ago. That does, I just received this this morning, Your Honor, so I apologize. I was unable to provide it to the court or the people in advance. But it states that he's working with a Marcus Pollard at Home of New Vision, working to help get him through access. They are waiting on a follow-up communication so he can proceed with the next steps in his recovery, hopefully to get into rehab. That being said, Your Honor, I do have the documentation as from the Home of New Vision from 2 days ago that Mr. Probst provided to me. He is willing to engage in community corrections testing. I believe he is confused.
He's missed 15 tests.
That is true, Your Honor. Yes.
And the 2 that he took, which were actually in September, he tested positive for cocaine.
That is correct, Your Honor. And then he was in jail and released on December 23rd. And obviously, I acknowledge he has not tested since he's been released from the jail on December 23rd. But positively speaking, he has been working with Home New Vision. He did go on the 29th. Again, he should have continued to go back, and I did advise him that that's what he's supposed to do. I would ask if the court would consider ordering him to go to community corrections today and possibly come back based on the test results.
I'll adjourn this to the 29th, 2026, 9 a.m. But at this point in time, the defendant needed to do something else. He has attorneys, he has all kinds of tools at his disposal. He has in his bonds revoked, defendants remanded. Calls case people versus Christopher Provey.
Jake County for the people, Your Honor.
Veronica Glenn on behalf of Mr. Provey, who should be appearing by Zoom.
Mr. Provey, state your name, please, sir.
Christopher Provey.
Thank you. You're requesting an adjournment.
Yes.
Turn this out to February 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you, Your Honor.
Thank you. Court calls case People versus Raymond or Ramon Raymond.
Now, Chadwick, the people.
Michael Gaddy is public defender on behalf of Mr. Raymond, Your Honor. I believe he should be on Zoom.
His name is there. Mr. Raymond?
Your Honor, he is currently he's appearing by Zoom today because he is also in a matter at Wayne County's Circuit Court I think it's their version of a final pretrial.
You need to take that cigarette out of your mouth.
I did, sir. I'm sorry. I was
What's your
already at
name?
work. Ramon Raymond.
All right. What do we do?
Your Honor, we'd ask the court to set this for an exam.
Discovery is complete.
To the best of my knowledge, Judge, there is video.
People have their witnesses available to 27.
Yes.
Preliminary examination in person, January 27, 2026, 9 a.m. before Judge Washington.
Thank you, Judge.
Bond will continue. All right. Thank you, sir.
Thank you.
Court recalls the case People versus Christopher Decker.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Grant Miller on behalf of Mr. Decker. He is in the hallway. If I can just grab him. Please state your name for the court.
Christopher Decker.
Your Honor, I believe we're still waiting on a criminal responsibility report from the Forensic Center.
Why would I be waiting at this level for the CR report?
I'm not certain, Your Honor. When I was speaking with the prosecution, they indicated we don't have the CR report back yet, and we haven't begun any negotiations because they were waiting on the CR report.
Typically a CR report, I don't know how far they're out doing that, but he was found competent. There isn't going to be a CR report because normally that's going to take place afterwards, and it's not normally dealt with on the district court level. It's dealt with on the circuit court level.
Yes, Your Honor. I would have asked for an adjournment for negotiation purposes then, because people hopefully will start negotiating.
I don't know, you needed to say that. I mean, I think they'd be willing to negotiate. I think there was a misunderstanding as to what they were waiting for, so it didn't need to be said that way. Quite frankly, that was very disrespectful to the people.
Then I apologize.
I'm not going to have it.
I apologize to the people. No disrespect was meant, Your Honor.
During this to February 5th, 2026.
Thank you, Your Honor.
And bond continue.
Have a nice afternoon, Your Honor.
Thank you, sir. Got to put that bond. Oh, not too bad, huh? What's the next one? Oh, it's 12:30? Okay, so we're back on track. All right, court's gonna stand in recess. All right. Court's in recess.
This guy.